90-second delay. And so coaches and family will be watching this. It'll be recorded and you can watch that as well. We have a truly all-star scoring panel. And so what I want to do is I'm going to have them run through and introduce themselves so all of you know who'll be making the decision about who advances to the national tournament. They have an incredible background. It's a great diverse group. It really is one of our best panels in quite a long time. And what I'll do is I'll moderate a little bit before we start. Judge Jackson, you're in my upper left-hand corner. This is kind of like Hollywood Squares. Nobody knows what that is. Brady Bunch. I'm still talking about my generation. That's way too out of time. Judge Jackson, you're in the upper left-hand corner. Could you introduce yourself to our students and tell them a little bit about your background?
Sure. Good afternoon, everyone. My name is Judge Gary Jackson, Denver County Court. Just retired on December 30th. This is my 50th year as a lawyer and a judge. I went to Denver Public Schools, graduated from George Washington High School, so I'm a patriot. CU undergrad, CU Law School. I am one of the founders of the Sam Carey Bar Association, which is the Black Bar Association in Colorado. And prior to being a judge, and I didn't become a judge until 68 years of age, but prior to being a judge, I was a district attorney, U.S. attorney, and owned my own private law practice for 37 years. I am excited to be here, look forward to your performances. So thank you so much for having me here. It's a pleasure.
Judge Jackson, thank you. And we'll just kind of go down along the line. The next person, at least I've got on my window, is Justice Richard Gabriel. Justice Gabriel, if you could introduce yourself.
Sure. Good afternoon, everyone. Congratulations to each and every one of you for making the championship round. That's huge. I'm Rich Gabriel. I'm one of the 7 justices of the Colorado Supreme Court, and you'll hear from one of my colleagues here momentarily. I am originally from Brooklyn, New York, although I've been in Denver for 30 years. First generation in my family to go to college. I went to college on massive financial aid. I went to Yale, where I majored in American history, and the University of Pennsylvania for law school. I worked for a federal judge in Baltimore, which is where I met my now wife. Moved to Denver, and then I started a large law firm in New York where I did business trials, business litigation. Followed my now wife to Denver in 1990 and joined a large law firm there where I also did business litigation and became had a specialty in intellectual property law, copyright, trademark, trade secret, and the like. I did represent some pretty fun people in that world. I represented Michael Jackson in a music copyright case here in Denver. I represented the Rockies baseball team when they got sued over Dinger, their purple dinosaur mascot. And sorry for your generation, but I was the lead national lawyer for the recording industry, and I was suing everyone for downloading music illegally. I'm sure none of you did that. I did that for about 21 years, and then I was appointed to the Colorado Court of Appeals in 2008 by Governor Ritter, served there for 7 years, and was appointed to the Colorado Supreme Court in 2015 by Governor now Senator Hickenlooper, and that's where I am today. So thank you, and I really look forward to your performances today. Good luck.
Justice Gabriel, thank you. We'll go right next door to that, at least on my sheet, to Judge Stephen Bernard. Judge Bernard, if you'd introduce yourself.
Thank you. My name is Steve Bernard. I'm the Chief Judge of the Colorado Court of Appeals. I was appointed to the court and sworn in July of 2006, and I became the Chief Judge in December of 2018. Before that, I was a prosecutor for 28 years, mostly in Adams County. I'm a Colorado boy. I was born and raised in Colorado Springs, and I got both my degrees from the University of Colorado. I look forward very much to scoring this round. I have done this before, and it is always, believe it or not, this is always one of the highlights of the public context that I do, because this is a great program, and I am looking forward to what I know will be your great presentations today.
Judge Bernard, thank you. And right next door, Judge Ted Tao. Judge Tao.
Good afternoon, folks. Congratulations on getting this far. I'm Ted Tao. I am on the Colorado Court of Appeals working with Judge Bernard. It's the second time in my life I've worked with Judge Bernard, as he was the assistant DA in Adams County when I spent 7 years as a prosecutor. I've done private practice, labor and employment work, consumer protection work, and then 7 years as a prosecutor. Then I spent 3 years running what's called the District Attorney's Council, which is the kind of a trade association for all of the prosecutors in the state. So I spent some time at the legislature lobbying and helping to write the criminal justice laws. And then I was put on the trial bench up in Brighton for about 7 years before moving to the Court of Appeals just a little bit over 3 years ago. I actually have high school and college age kids who my daughter didn't participate this year, but last year my son participated in the mock trial competition for Stargate High School and had a good time with it. So I know you guys have been working hard because I saw how hard he worked at it.
Judge Tao, thank you as well. We'll come down next. The next person I see is Carolyn Gravitt. Ms. Gravitt, if you'll introduce yourself.
Hi. Well, thank you, Judge Madden, for having me. And it's so exciting to be on this panel with some of my favorite people in the whole world. I was a director at the Bar Association for 17 years. I ran this program for 17 years. You can blame me for those rules, including the unfair extrapolation rule, but I'm going to put most of that on Judge Madden. Besides Judge Madden, I'm probably the biggest mock trial junkie here. I've attended 14 national tournaments. I transitioned in 2019 to the Colorado Women's Bar part-time just to focus more on my family and other things. And I'm just ecstatic to be here and I can't wait to see your performances. Congratulations to getting this far.
Thank you. Next, I've got Nicole Speraza. Ms. Speraza, if you'll introduce yourself.
Good afternoon. Congrats. I echo all of my esteemed scoring panelists. I'm honored to be here and to be judging this final round for you all. I know it's been a long time coming, it seems, and lots of weekends and time before that dedicated. A little bit about me. I am actually the daughter of an immigrant, so I'm first generation Korean American for my family. Obviously went to law school. I've been in Colorado since middle school, up in Summit County. I went to Summit County Middle School and went to CU Boulder for undergrad and then DU for law school. I'm currently the chair of the CBA Litigation Section Council, which is how I was able to join this esteemed panel today. The CBA Litigation Section does do quite a bit of funding for the mock trial program, which we're happy to fund every year. So I'm honored to be here. I'm also a past president of the Asian Pacific American Bar Association, and I'm pretty involved in the CBA and DBA as well. So I think it goes with everybody, saying congratulations again. If you have any questions, if you want to reach out, please feel free to do so. After the conclusion of everything, I would be more than happy to talk to any of you if you're interested in pursuing a legal career or just have some questions. It's definitely an open door and open Zoom policy. So thanks for having me.
Speraza, thank you very much. And just because it ended up in terms of the location, I'm going to wrap up with Justice Maria Birkencarter. Justice Birkencarter, if you would introduce yourself as well.
Yeah, thank you, Judge Madden. So I'm Maria Birkencarter. I am the newest justice on the Colorado Supreme Court. I was just sworn in on January the 4th. So I'm the new kid, although obviously I'm not a kid. Congratulations to all of you for being here in the mock trial championships. It's an amazing accomplishment. I'm tickled to have the chance to be here with everybody else and to score. In terms of my background, I went to University of Denver for law school. After law school, I spent a year clerking for a justice on the Colorado Supreme Court, Howard Kirschbaum. Then I was in private practice for a couple of years. And after I realized that there were folks at the firm, and it was a great firm, learned a lot, but that, had been there for 5 years and weren't doing depositions, I moved to the Colorado Attorney General's office. I was there for 16 years. I eventually ran consumer protection, antitrust, tobacco litigation. Most of my own practice was civil and criminal antitrust, which was terrific. I was appointed to the Boulder District Court bench in 2006. I stayed as a district court judge for about 11 years. I was the chief judge the last 4 years of that time. Then I went to a place called Judicial Arbiter Group. I was there for 3 years until I was just appointed to the Supreme Court. So that's kind of been my path. And I would echo what Nicole said. If any of you want to chat at any point in time, please feel free to reach out. I'd be happy to chat with any of you over Zoom. Best of luck to all of you. I'm really excited to get to see your presentations.
Wonderful. Thank you all very much. I'm not going to say much because really I'm not scoring you in this regard, but I'll throw that out. Obviously, as I think you can hear, some of our panelists probably would be even better judges than I would be through the process. I just get to do this because I'm the chair of the committee and I helped write the problem with this. I was a Denver District Court judge for almost 15 years. I've recently left that to work in the Judicial Arbitration Mediation Services. It's like a Judicial Arbiter Group, it's JAMS. But I'll be the presiding judge. I'll be making the rulings. But those 7 people you've just heard from are the ones who are going to be scoring you for this process. They're the critical ones in that regard. Without much more ado, for each of our panelists, this time I'll let you feel free to go ahead and you can turn off your cameras and microphones so you can watch in peace without trying to be online and keeping that there. What I'll say is for any of our panelists, if you in turning off the camera, still see black boxes with people's names. This is a reminder, if you hover your cursor over the right-hand corner of one of those black boxes with the names, you should get chat pin or hide non-video participants. If you click hide non-video participants, they will all disappear. What I'm going to go ahead and do is for our panelists, if we lose you at any time, if you can let one of us know right away, either Amy Shreenan or Ashley Staub or myself, we will stop the process of the trial till we can get you back in. For any of our
cell numbers in the chat as well, Judge Madden.
Oh, excellent. So for our panelists, I should have done this before. If you want to go ahead and write down Ms. Shreenan's cell phone number so that you can call her if you get disconnected, and we'll stop the trial till we can get you reconnected. And the same thing for any of our competitors. My guess is you'll probably tell one of your teammates. If they'll tell me, we'll stop until we get everyone back in. What we'll do is once we get the round going, what I'd like to do is I'll keep my camera active so I can rule on any objections that are made and proceed. And what we'd like to do is the participants in that particular presentation, both of you keep your cameras active, and for an examination, both attorneys and the witnesses keep your cameras active. And if you're not actively participating, we'll have you turn off your microphone and camera. Timekeepers, of course, can turn on their cameras again to alert your teammates if we're running out of time in that regard. And then very briefly, just in terms of some background before we start, just as a reminder that the Bar Association could be taking photographs of the competition or screenshots. This round will actually be recorded and go out on YouTube. And by participating, that is permission and agreement that we can use the photographs for promotional materials. In fact, usually we end up having some of the winners and probably will have all of the participants in next year's case problem in that regard. There won't be any recesses except in cases of emergencies, something along that line. So we don't take a break at halftime or right before closing arguments. We'll try to proceed right through that. Certainly, if somebody has an urgent issue, let me know. And if it truly is that version of I absolutely have to take the restroom break, let me know that as well. But we'll try to push all the way through. Other than that, we'd had the panelists. We've advised them if they thought they recognized any of you to the point that they thought they couldn't be fair, to let us know. I've not seen any of that come through as well. We'll probably take a group photo toward the end with that as well. I wanted to come back to that. But if any of you said, wait a minute, I knew one of our scoring panelists, that's a relative of mine, or I was an intern with them, let me know that now. But other than that, we're presuming at this time there's not a conflict of interest. We'll be ready to start the trial in just a moment. Please keep in mind that you do have to comply with the time requirements. Going over your time, not only can the other team come on and say that you've hit the time limit, not being able to complete your presentations in the time allotted will be considered by the scoring panelists and the scores. And with that, I want to make sure I haven't missed any critical steps. And certainly, by the way, as a reminder, if there's any disputes, I think all of our participants know we have in the bar disputes and outside the bar disputes. Outside the bar disputes can be handled by coaches and teams, but those are things that have happened not in this room. So if there's something that you notice that's a rules issue, make sure that alert me at the end in terms of an in the bar dispute. Given your professionalism scores that I saw for both of you, I'd be shocked if we had anything along those lines. But if something comes up, let me know before we recess at the end. And other than that, I think we're ready to proceed, and I'd like to start with introductions of the participants. Let me go ahead and start with the prosecution, and I'll officially call the case of the people of the state of Colorado versus Avery Becker. And at this time, we'll begin with introductions and entries of appearance. If I could begin with the prosecution, please, and your entries of appearance.
Good morning, good afternoon, Your Honor, counsel, members of the jury. My name is Feliciana Sayers, and I represent the people of the state of Colorado.
Good afternoon, Your Honor, counsel, and members of the jury. My name is Chalmers Powell, and I represent the people of the state of Colorado.
Good afternoon, Your Honor, counsel, members of the jury. My name is Madeline Proctor, and I represent the people of the state of Colorado.
Good afternoon, Your Honor, counsel, members of the jury. My name is Trenton Schultz, and I am Detective Jordan Markowitz.
Good evening, Your Honor, counsel, members of the jury. My name is Ben Phillips, and I am Kyle Kuzak.
Good afternoon, Your Honor, counsel, members of the jury. My name is Julia Bruner, and I am Alex Cifuentes.
All right, and with entries of appearance then by the defense.
Good afternoon, Your Honor, and members of the jury. My name is Grace Murphy, and my co-counsel and I represent the defendant, Avery Becker, in today's case. Permission for my co-counsel to introduce themselves?
They may.
Good afternoon, Your Honors. Your Honor, members of the jury. My name is Lola Fakes.
Good afternoon, Your Honors and member of the jury. My name is Tess Hayden.
Permission for our witnesses to introduce themselves?
They may as well.
Good afternoon, Your Honor, members of the jury. My name is Lily Humber, and I am Professor Blake Van Owen.
Good afternoon, Your Honor, members of the jury. My name is Saffron Bennett Spurlock, and I am Avery Becker.
Good afternoon, Your Honor, members of the jury. My name is Alexander May, and I am Taylor Perkins.
Thank you all. If I could have all of our participants, and we'll have you activate your cameras for this, if I could have you each raise your right hands. For our team members, do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes,
yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Thank you. For our witnesses only then, if you'll keep your right hands up, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Thank you. You lower your hands. For our scoring panelists, I won't make you turn your cameras back on, but if you'll just agree with me in terms of this, do you promise and adjudicate that the mock trial competition, do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts and procedures and rules of the mock trial competition?
I do.
Yes.
Thank you all very much. And I've heard the I do's. That'll work. For our gallery members, although you're watching via the YouTube live stream, this includes teachers and attorney coaches and family members and friends. At this point, we expect that under the rules of the process that you will represent yourselves as positive role models and behave in a manner that exemplifies ethical and professional sportsmanship. During the round is less of a concern by Zoom these days, but after the mock trial as well. All of you have been exceptional role models to this point, exceptional coaches. We appreciate that. But with that, we're ready to begin the trial. What I'd like to do is go ahead and start with some preliminary or housekeeping matters. Let me start with the prosecution. Did you have any preliminary matters?
Yes, Your Honor, the people have 4 preliminary matters.
All right.
For our first preliminary matter, the people request that the stipulated facts be constructively read into the record.
All right, and those are included in the case materials, and so it will be presumed that they have been read into the record and the stipulations are part of the case. If you want me to read a particular stipulation, simply let me know.
That won't be necessary at this time, Your Honor. For our second preliminary matter, the people request that the jury instructions be constructively read into the record prior to closing argument.
you can presume that constructively before the closing arguments, the jury instructions would be read and you may utilize them as such.
For our third preliminary matter, the people request that any time remaining in Mr. Powell's closing argument be reserved for rebuttal.
That is granted as well. And so you don't have to request a reserve rebuttal for the people. Any remaining time you may use in your rebuttal.
Finally, Your Honor, for our third preliminary matter. As the court is keenly aware, COVID-19 has brought on new challenges for courts, especially in the presentation of evidence. The people are pleased to announce that prior to trial, we conferred with the defense and have a proposed stipulation for the virtual presentation of evidence. Our proposed stipulation is as follows. The people request that while entering an exhibit, we ask the witness and counsel to refer to their case material. And if it is admitted, we ask that it be screen shared to the jury.
And is it correct from the defense that's your stipulation as well?
Yes, Your Honor.
In candor, I think that's the best process. In other words, we'll treat it a little bit like it's an exhibit notebook. You'll be able to simply refer the witness to that particular exhibit. That allows the court to do the same. And then once it's admitted, then if you'd like to screen share at that point, that's perfectly acceptable. So that stipulation, if I've stated it correctly, is absolutely acceptable to me. And if I've misstated it, let me know.
Yes, Your Honor. With that, the people are ready to proceed.
All right, let me go to the defense then. Does the defense have any additional housekeeping or preliminary matters?
No, Your Honor.
All right, in that case, we'll move to the beginning of the trial, which will be the opening statements, beginning with the prosecution's opening statement. And I take it, Ms. Proctor, you'll be giving the opening, is that correct?
Yes, Your Honor.
Prior
Yes,
to
Ms.
opening statement, Ms. Bruner got kicked out of the meeting. If she could be let back in.
That's exactly what you need to tell me for that. I appreciate that. We'll try to let her back in. Let me take a look at our participant list.
I can let her back in when she jumps in here.
Oh, thank you very much.
Your Honor, may I proceed or should I wait for Ms. Bruner?
Let's wait for Ms. Bruner just to be safe.
Yes, Your Honor.
Well, and I take it, actually, Ms. Bruner's on your team. Is that, well, we'd like to let her see your performance, so that'll work. Ms. Serena, and if you see her coming, let me know that when she's back.
Do that.
And Ms. Proctor, just so I know, what role does Ms. Bruner play?
She plays Ms. Cifuentes, who is last in our witness order, if that helps.
Given that, since you're probably ready to proceed at this point, I think both counsel are. If it's acceptable with the prosecution, we could go ahead and begin with the opening statements. and then we'll get Ms. Bruner admitted at the time so you don't have to stand and wait uncomfortably. Would that work for the prosecution?
Yes, Your Honor.
Let's do that
She
then.
just came in too.
Perfect timing. I stalled just long enough. In that case, we'll begin with the presentation of the opening statements. Ms. Proctor, when you're ready, you may proceed.
Towers, texts, and tantrums. Mackenzie Brackman was an attorney. Running around all day was just part of the gig. He also volunteered his time at the local high school as a mock trial coach. So for him, moments of rest were few and far between. On March 6, 2020, though, he finally got one of those moments. No more worrying about his upcoming trial or reports of the coronavirus coming to the United States. No. Today was his day to focus on himself. Ding, motion at your front door. Ding, motion at the side gate, and as the back door slides open, one more alert. It all happened so quickly, and Coach Brackman reached for a defensive weapon. One moment he was relaxing, and the next he was fighting for his life. But before he knew it, there was a knife in his back, and he was bleeding out on the floor. The masked and hooded intruder fleeing the scene. Turns out that attacker was Avery Becker. Your Honor, counsel, members of the jury, my name is Madeline Proctor, and together with Feliciana Sayers and Chalmers Powell, we represent the people of the state of Colorado. Now, we have the burden in today's case to prove beyond a reasonable doubt that the defendant, Ms. Becker, committed the crimes of second-degree burglary, which is criminal mischief, and by extension, first-degree murder. We will meet that burden. For now, focus on three things: towers, texts, and tantrums. Towers. Detective Markowitz used cell tower records to find out where Avery Becker was on March 6th. Those records prove that she was at the home of Mackenzie Brackman during the time of the break-in and the murder. Her phone pinged not just once, not twice, but 3 times in the same cell tower arc as the victim's home. Texts. Alex Cifuentes received text messages from the defendant's phone, threatening to break into Coach Brackman's house and vandalize it. These messages were sent the day before the murder, and they paint a portrait of the defendant's motive to go to Coach Brackman's house on March 6th, break in, and vandalize it. Tantrums. Avery Becker went to Coach Brackman's house to vandalize it. It was a burglary gone wrong. You see, Miss Becker had won some awards at the regional mock trial tournament, but Coach Brackman told her she did not deserve those awards. So what happened? Miss Becker got mad, and she took a Sharpie to Coach Brackman's car. When he saw what she had done and kicked her off the team for good, Miss Becker got even madder. This gave her all the motive in the world to go to his house, break in, and vandalize it. The defense has no obligation to present evidence in today's case, but we expect that they will. Their purported expert is only hired to judge other people's work, and she has no investigation of her own. Ms. Perkins is loyal to the defendant, and she has proven in the past that she will go to extreme measures to help out her friend. And the defendant has every possible reason not to tell the truth. Members of the jury, the case in front of you today is a tragedy. Coach Brackman dedicated his life to helping shape the future leaders of America. He was a shining star in the community, but that light extinguished when he bled out on his floor on March 6th. Towers, texts, and tantrums. At the end of today's trial, Mr. Powell will stand before you and walk with you through the evidence. He will ask for a verdict of guilty. Thank you.
Ms. Proctor, thank you very much. Is the defense ready to give its opening statement?
Yes, Your Honor.
Ms. Fakes, when you're ready, you may proceed.
Thank you, Your Honor. No phone, no files, no felony. Your Honor, members of the jury, my name is Lola Fakes, and my co-counsel and I are here today to represent Avery Becker. Ms. Becker stands here today falsely accused of second-degree burglary of a dwelling and murder in the first degree. The prosecution accused Avery Becker of Mackenzie Brackman's murder before their investigation even began. They investigated no other leads or suspects, and the incomplete evidence they will present today will clearly reflect that. The prosecution's case is, simply put, unfinished. The prosecution will call 3 witnesses to the stand. They will call Alex Cifuentes, the prosecution's only character witness, who is a mock trial teammate, jealous of Avery's recognition in mock trial competitions. You will hear that Alex was the last person to see and use Avery's phone on March 5th, the day before the murder, the same night Avery's phone was lost. Texts. Alex claims to have had a text exchange with Avery about her plan to go to Mr. Brackman's house. Now, you will also hear from Detective Jordan Markowitz, who will try to explain why he accepted screenshots of this purported text exchange directly from Alex, with no attempts to verify the authenticity. None. Towers. You'll hear that cell tower data collected by Detective Markowitz from Avery's phone the day of the murder cannot tell us where Avery's phone was that day, as phones do not always connect to the tower closest to them. Professor Van Owen, the crime scene investigator who will testify later today, will explain cell phones commonly connect to towers up to 7 miles away from a phone's location, meaning his cell phone in downtown Denver could connect to a cell tower in Stapleton. While the data may give us a picture of the phone's location, it can still tell us nothing of the location of Avery the day of Mr. Brackman's murder. Detective Markowitz has failed to locate Avery's phone. Detective Markowitz has failed to obtain Alex's phone to authenticate the purported text messages. The detective has also failed to locate the one phone that could confirm or deny their lead suspect's alibi, Taylor Perkins' phone, as Taylor was with Avery on the day of the murder. Where is Avery's phone? Where is Alex's phone? And where is Taylor's phone? All untouched by the police and not in court today. Kyle Kuzak will also be called to the stand. Kuzak, a worker for the police, will try to reconstruct the crime scene for the court, but will fail to do so properly or convincingly. Kuzak used only the evidence that Detective Markowitz collected, following Markowitz's leads. Additionally, the police allowed important picture evidence to be corrupted, making it unavailable to the court today. Members of the jury, this is just another example of the unacceptable incompetence of the detective work on this case. The defense will bring to the stand crime scene investigator Van Owen. Professor Van Owen will help highlight the failings of the police investigation, of scuff marks that aren't dated, unchecked ring notifications, and the impossibility of a teenager of Avery's stature to reach the knife wound found on a grown man's shoulder. You will also hear from the defendant herself, Avery Becker, who will clearly explain to you that she did not commit this crime. Lastly, you'll hear from Taylor Perkins, Avery's indisputable alibi, who will fully corroborate the whereabouts of Avery on the day of Brackman's murder, making it ever more clear that Avery had absolutely nothing to do with this crime. Members of the jury, Mackenzie Brackman was a criminal defense attorney, a job that will naturally provide you with enemies, and Detective Markowitz will fail to acknowledge any other suspects in this case. Taylor Perkins will bring your attention to Blair Rollins, a fellow Colorado high school student whose father is now in jail by the hands of Mackenzie Brackman's lawyering. You hear that Blair Rollins was not at school on the day of Mr. Brackman's murder. You will also hear that Blair Rollins seems to have recently disappeared. You will not hear of any investigation of Blair Rollins by the prosecution. No phone, no files, no felony. The investigation on Mackenzie Brackman's murder was lazy. The prosecution found only the evidence that supported their claims and ignored to look into any other leads, theories, or pieces of evidence that would contradict their choice of suspect, Avery Becker. The prosecution wants to hinge their case on texts, towers, and tantrums. Texts that aren't real, towers that tell us nothing, and tantrums over being kicked out of an extracurricular activity don't make a murder, members of the jury. I will remind you that the prosecution holds the entire burden of proof in the case. I ask the jury to keep in mind that the prosecution must prove their case beyond a reasonable doubt. It is your job, jury members, to ask yourself, through every moment of testimony today, if there is any reasonable doubt. I ask that you remember what the prosecution is missing from their case. No phones, no files, no felony, and find my client, Avery Becker, not guilty. Thank you.
Thanks. Thank you very much as well. Given that, then we'll go ahead and move to the next phase of the trial, which is the presentation of the evidence, beginning with the prosecution's case in chief, Is the prosecution ready to call your first witness?
Yes, Your Honor. The people called Detective Jordan Markowitz to the stand.
All right, Detective Markowitz, if I can have you be there, and I see we have opposing counsel. Detective Markowitz, you've already previously been sworn, so I won't swear you back in. You've been sworn in as a witness. I'll turn this over to your counsel. And Mr. Powell, if you're ready, you may inquire.
Good afternoon, Detective. Please introduce yourself to the jury.
Good afternoon. My name is Jordan Markowitz. That's Markowitz.
Let's talk about your professional career. What do you do for a living?
Currently, I'm a homicide detective for the Denver Police Department.
How long have you been on the force?
I started my career with the DPD about 13 years ago, and for the past 7 years, I've been exclusively a detective.
Over those 7 years, what skills have you acquired?
I have grown and developed many skills, especially skills concerning cell phones and forensic data recovery.
What does that mean?
This means I have the ability to acquire and decipher cell phone data, records, and cell tower data, in addition to the skill to use forensic software such as the Celebrate system.
Tell us about your specialized training.
Besides attending the Basic Police Academy, I also attended the American Academy of Law Enforcement.
What did you do at that academy?
While I was there, I attended a certification class in which I took a test to become certified in cell phone technology and forensic data recovery.
And how many times have you used that training?
I have downloaded and interpreted the contents of hundreds of phones. In addition to that, I have obtained and analyzed cell tower data in over 50 cases.
Your Honor, the people request the court to recognize Detective Markowitz as an expert in the field of police procedure, cell tower analysis, and forensic data recovery. Pursuant to which his skill, knowledge, and education have been shown.
Thank you. Was there any objection or voir dire?
No voir dire at this time, Your Honor. I'll address the shortcomings of Detective Markowitz's investigation on cross.
All right. At this point, then he'll be accepted under Rule 702 and may offer opinion testimony in those areas that you've designated. You may proceed.
Detective Markowitz, how did you begin your investigation?
As someone who works to collect and interpret evidence, first, it's crucial that I remove myself and any personal bias that I might have. It's my job to follow the evidence and let it take me to the truth.
All right, let's start at the beginning. March 6th. What happened that day?
I was dispatched to 444 South Flower Street near Broomfield, Colorado. I arrived at approximately 1400 hours.
Upon arriving at the scene, what did you discover?
I found a Caucasian male, approximately 50 years old. He had been stabbed 1 centimeter below his left inferior scapular angle, approximately here, and had died of exsanguination. He bled out.
So how did you begin your investigation of the crime scene?
I started by working backwards. After examining the victim, I noticed a trail of blood droplets leading to the kitchen, so I followed them.
What did you find in the kitchen?
In the kitchen, we found several relevant pieces of evidence: a knocked over chair, a broken plate, an open knife drawer, a knife missing from the knife block. This was all evidence that clearly indicated that a struggle had occurred.
After investigating in the kitchen, where else did you investigate?
After investigating the kitchen and clearing the inside of the home, I began investigating around the outside of the home.
What did you find there?
I found 3 different Ring security cameras, one at the front door, one by the side gate, and one at the back door.
What can be seen on these cameras?
In these cameras, you can see someone wearing a mask, gloves, and a big hood approach the front door and try to enter. They're unsuccessful, so they move around through the side gate to the back door where they were able to enter.
Let's talk about how you found that person in those Ring videos. How did you begin your investigation of possible suspects?
I began my investigation of possible suspects by downloading and analyzing Mr. Brackman's phone. I discovered that he was involved with mock trial at Colorado High School, and judging by the number of emails and texts he received, he was extremely involved. Through this involvement, I was able to get in touch with one of the members of the team, Alex Cifuentes.
What did you learn from Alex Cifuentes?
After a call and an interview with Ms. Cifuentes, I found out that the defendant had recently vandalized Mr. Brackman's car and was removed from the team for it. then in an attempt to
Objection,
be
Your Honor.
reinstated on the team.
Basis of the objection?
Hearsay, Detective Markowitz is testifying to an out-of-court statement by Alex Cifuentes.
And Mr. Powell, your response?
Your Honor, we are not offering this for the matter asserted, rather the effect it had on Detective Markowitz in furtherance of his investigation.
Right. And why is that relevant in the case?
Why is Detective Markowitz's next step in his investigation relevant?
Or why is it that knowing what he knows, how does that make that relevant in terms of the investigation?
Your Honor, I'm laying foundation for the next step of Detective Markowitz's investigation.
Thank you. And Ms. Hayden, any reply?
Your Honor, I would argue that stating that Avery rode on Brackman's car is offered for the truth of the matter asserted and therefore is hearsay.
All right. At this point, what I would do is, since I believe we'll have other testimony directly on that, I'll find that it can be offered for the non-hearsay purpose of explaining what steps the detective took next. For our jurors, unless and until there's testimony as to what happened, please don't accept that for the truth of the assertion, but just to explain what Detective Markowitz did. And with that, the objection is otherwise overruled. Mr. Powell, you may continue.
Detective Markowitz, after hearing that the defendant rode on Mr. Becker's car, what did you do then?
Well, also in the interview, I questioned Alex Fuentes if anything came of that, and it did. Miss Becker, the defendant, texted Ms. Fuentes asking for help to be reinstated on the team.
Objection, Your Honor.
All right. The basis?
The prejudicial value highly outweighs the probative effect of entering these texts at this time.
And what is, you think, the unfair prejudice?
I believe that by opening the door to these texts, Detective Markowitz is going to discuss further the content of these texts. And although I understand that they are not hearsay as they are from a party opponent, I do believe that they are being offered for the truth of the matter asserted, and therefore the prejudicial effect of these texts in general being entered through Detective Markowitz highly outweighs the probative value.
For the prosecution, your response.
Your Honor, the probative value of these text messages is not substantially outweighed by their prejudicial effect. The probative value of these text messages shows that the defendant had the intent to commit criminal mischief and went to Mr. Brackman's home on March 6th.
All right. And we're not actually to the point of the entry of those, but I think we're laying that foundation. So presently, in terms of those questions, I will overrule the objection, but also at this point, I don't think the risk of unfair prejudice outweighs the probative value. So I'd overrule the objection along those lines as well. With that then, Mr. Powell, you may continue with your questions.
What did you learn about the text messages, Detective?
I learned that there was text between Alex Fuentes and the defendant regarding her standing on the team and then furthermore, her plan.
Detective Markowitz and Ms. Hayden, please direct your attention to Exhibit 14. Detective Markowitz, what is Exhibit 14?
This is a copy of the screenshots I was provided with by Alex Fuentes of the text between Ms. Fuentes and the defendant.
Are these a fair and accurate copy of the screenshots Ms. Fuentes sent you?
Yes, sir, they are.
Your Honor, the people request that Exhibit 14 be admitted to evidence for its accuracy and authenticity have been shown.
And Ms. Hayden, any objection? And certainly you can preserve your prior objection if you wish to do so, but any objection to Exhibit 14?
Yes, Your Honor. Under Mock Trial Rule 1003, obviously duplicates are normally admissible. However, in this case, there's a serious question as to the authenticity of these actual texts. Therefore, a duplicate is inadmissible. Seeing that Detective Markowitz has no way of actually proving the true authenticity of this conversation, this duplicate is not admissible.
All right, it's a best evidence issue. Mr. Powell, your response in terms of best evidence.
Your Honor, pursuant to Rule 1004A, the originals of the screenshot or of these text messages were lost and not in bad faith of Ms. Fuentes. Therefore, the duplicate of these text messages is admissible.
And I usually don't necessarily go back and forth, but it's a different issue. Ms. Hayden, your response in terms of 1004.
First of all, Your Honor, I would appreciate it if Mr. Powell will not testify the faith of Alex Fuentes when losing these text messages, but my argument still stands. Under Rule 1003, these texts are not admissible as duplicates, seeing there's a serious question as to their authenticity.
All right. And I take the argument not to be necessarily comments on another individuals, but on the proponents. And under Rule 1004, it is an exception to best evidence if all of the originals have been lost or destroyed, so long as it's not by the bad faith of the prosecution in this case. It's the spot on issue for both sides, but under the circumstances, I'm going to overrule the best evidence objection, maintain my ruling on the prior issue in terms of 403. Noting the objection, Exhibit 14 is admitted, and you may proceed.
Your Honor, permission for Ms. Sayers to screen share Exhibit 14 to the jury?
She may.
Detective Markowitz, what in these text messages furthered your investigation?
There are two texts in particular that stood out to me. The first one being, well, if he's upset about his car, then he's going to be really upset when he sees what I do to his house. The second one being, I'm going to wait until he's at work, then break in and trash it.
Thank you, Ms. Sayers. Detective Markowitz, other than that, what else led you to suspect the defendant?
Upon further examination, the call detail records provided information about the location of the defendant's phone on the day of March 6th.
What are call detail records?
Call detail records, or CDRs, are accurate records of when phone calls or text messages were sent and received to a specific phone.
Detective Markowitz and Ms. Hayden, please direct your attention to Exhibit 16. Detective Markowitz, what is Exhibit 16?
This is a copy of a map that I overlaid with cell towers and their arcs.
Is this a fair and accurate copy of that map?
Yes, sir, it is.
Your Honor, the people request Exhibit 16 to be admitted into evidence, for its accuracy and authenticity have been shown.
Any objection to 16?
I have no problem with 16, Your Honor.
All right, given that there's no objection, Exhibit 16 is admitted.
Your Honor, permission for Detective Markowitz to screen share to the jury.
You may.
Detective Markowitz, can you show us what this map means?
Looking at the first tower, the one I'm circling in blue, the first ping was from Avery's phone was made at 12:47 at this tower covering the defendant's home. The second ping was made to this tower right here, I'm circling in yellow, at 12:55. Notice how this sector of the cell tower does not cover the mall nor the fry shack, but rather a possible route from the defendant's home to the victim's home. Then the third tower I'm circling in red pings at 3 different times, 13:05, 13:06, and 13:17. This tower covers the victim's home.
Thank you, Detective. What does the phone ping 3 times at the victim's home prove?
The phone pinged to the same cell tower 3 times means it is highly likely that the phone was within that vicinity, the same vicinity as the defendant's home. Or sorry, the victim's home.
Detective, let's talk. You can stop screen sharing now. Let's talk about your conclusions. In your review of all of the evidence and based on your experience, what conclusions did you come to in this case?
In my expert opinion, first, the intruder tried to enter through the front door, but was unsuccessful. So she moved around to the back door through the side gate and was able to unlawfully enter the home of Mr. Brackman, in which events ensued that ended with Mr. Brackman being stabbed in the back, falling at his front door, and bleeding out.
Why is that your conclusion?
Looking at the totality of the evidence in this case, I was able to come to this conclusion.
And who can you conclude the intruder was?
I concluded that the defendant, Avery Becker, was the intruder in this case. Looking at all the evidence, especially the texts and towers, allowed me to make this conclusion.
Can you identify the defendant here today?
Yes, sir, I can. She was the one who you saw in introductions with the light brown hair and the light blue shirt.
Thank you, Detective. Your Honor, I have no further questions at this time.
Give me one moment. Hold on just a second. My apologies for that interruption. Let me come back to Ms. Hayden. Any cross-examination?
Yes, Your Honor. May I proceed?
You may proceed.
Detective Markowitz, when a criminal defense lawyer is violently murdered in their own home, your first assumption is often a disgruntled ex-client. Isn't that right?
It's always a first possibility. However, in this case, no evidence pointed towards that.
Right. In this case, the only suspect you looked into was a high school girl who Brackman coached in mock trial.
Ma'am, in this case, I followed the evidence. I did not pick a suspect and push evidence towards them. I simply followed the evidence and let them come to their natural conclusions.
Please answer my question, Detective Markowitz. Your only suspect in this case was a high school girl Brackman coached in mock trial, yes or no?
That is not correct. Blair Rollins was another suspect. In fact, you could see him on the map in Exhibit 16. However, no evidence pointed to him.
We'll return to Blair Rollins. Let's first discuss the day of the murder. You said that Mr. Brackman armed himself with a knife from his kitchen, isn't that right?
That was my conclusion, yes.
And you do not know whether the intruder had a knife in their pocket or waistband or anything like that, do you?
I was not there, obviously, when the crime occurred, and the ring videos, you cannot see what is inside the pockets of the intruder. So no, I could not see if they had a knife with them.
Does the knife used to murder Mr. Brackman match the other knives in the knife block?
No, ma'am, it does not. However, that does not change the fact that that was a knife used to stab Mr. Brackman.
Therefore, the knife used to stab Mr. Brackman, as you say, could have been the intruder's knife. Isn't that right?
It is possible, or it could have came from the knife drawer.
You say that a struggle ensued in this case. Isn't that right?
Yes, ma'am.
And some of your only evidence of this surmised struggle, photos of blood spatter, was lost by your police department.
Yes, not in bad faith, but they were lost. They were corrupted.
So the jury cannot use these photos to make their determination today.
No, ma'am, they cannot.
Mr. Markowitz, how did you say that Mr. Brackman knew the intruder was coming?
It was possible that he received a ring notification, or it was possible he heard the shaking of his front door, or it was possible he heard his side gate open. And finally, it could have been possible that he heard his back door open and saw the intruder entering.
And it is your belief that Mr. Brackman got a ring notification, isn't that right?
Yes, I do believe he did. However, if he didn't, he still would have been alerted.
Thank you. Even though Ring doorbells can alert their owners, you provided no evidence today that the Ring doorbell the alerts were turned on, did you?
No, ma'am, I did not.
And you said yourself that you've downloaded the contents of hundreds of phones, isn't that right?
Yes, ma'am, I have. And I did.
But you didn't
download the contents of Mr. Brackman's phone.
Thank you. But you didn't bother to look through Brackman's phone to find out if his Ring notifications were on, did you?
I did not see it relevant to look at the notifications. There were multiple factors that could have played into his alertness of the intruder.
Thank you. If my trial technician could pull up what has been previously entered as Exhibit 16.
They may show that if that's where we're waiting. There we go.
Thank you. Okay. Detective Markowitz, as you testified just a moment ago, there's a third house on this map, isn't there?
Yes, ma'am. Blair Rollins' house.
And Blair Rollins' house is in the same cell tower range as Becker's.
Yes, ma'am, it is.
Detective Markowitz, are you aware that Mr. Brackman sent Blair Rollins' father to prison for life?
I am aware.
And despite this truth, you chose to leave out Blair Rollins entirely from your affidavit.
I did. You see, there was no evidence that pointed towards Blair Rollins in this case.
Is it your statement here today that there was no evidence that pointed towards Blair Rollins in this case?
Ma'am, other than his house being in the same cell tower arc, there's simply no evidence that points towards him.
Is it your statement here today that all other evidence did not point towards Blair Rollins?
Yes, ma'am.
Even though, are you aware that Blair Rollins is the same height and build as Avery Becker?
Yes, there are millions of people with the same height and build.
Are you aware that Blair Rollins was on the same mock trial team as Avery Becker?
I was not aware that Blair Rollins was on the same mock trial team as Miss Becker.
Are you aware that Blair Rollins' father is still in prison because of Mr. Becker?
I am aware of that, yes.
Let's discuss those texts. You looked into Avery because of some texts between Alex Cifuentes and the defendant, isn't that right?
That was my first lead into the defendant, yes, ma'am.
And the only evidence of those texts are screenshots.
And Alex Fuentes' call with me before the interview and the actual interview itself. All three of these things matched up.
But if these screenshots were fake, you would have no way of knowing, would you?
I'm sorry, I don't understand your question.
If these screenshots were faked by Alex Cifuentes, would you have any way of knowing?
I would, yes.
Yes or no? Is it your testimony here today that you know that these screenshots are not faked?
I cannot say if I know they are not faked. However, the evidence points away from that.
Did you investigate Taylor Perkins's phone to confirm Avery's alibi?
Of course I didn't. It would prove nothing.
Did you investigate Avery's phone to confirm this text conversation?
I was not allowed to, ma'am.
And you never looked into or included in your affidavit any other suspects besides Avery Becker, isn't that right?
No, ma'am, not in my statement.
Thank you, Your Honor. No further questions.
Thank you. Was there any redirect examination?
Yes, Your Honor. Detective Markowitz, why did you rule out Blair Rollins as a suspect in this murder?
Sir, there was simply no evidence other than being in the same cell tower arc as the defendant.
Objection, Your Honor.
Basis of the objection?
Move for the last statement to be stricken as it is not within the facts of this case, that there was no other evidence pointing towards Blair Rollins.
And let me ask, are you making an unfair extrapolation objection or is it a different objection?
I can, Your Honor, yes.
But it's your call. I don't want to guide you either way. I just want to make sure I understand the basis. Was this an evidentiary basis under the rules of evidence, or is it a procedural objection?
If Detective Markowitz would like to stand by the statement that there was no other evidence pointing towards Blair Rollins, I am, yes, making an unfair extrapolation objection.
All right. Let me let you go ahead and address that. And I want to come back to Mr. Powell, your position in terms of unfair extrapolation, if it's a material statement or if it's in the case file.
Your Honor, Detective Markowitz didn't testify and hasn't stated anywhere in his statement that there was evidence that Blair Rollins was a suspect in this murder case. Therefore, it would be a reasonable inference that Detective Markowitz had no evidence that Blair Rollins was the murderer in this case.
All right. And then I want to come back to defense counsel. Any reply in terms of that?
I would argue, Your Honor, that first of all, there most certainly is evidence that Blair Rollins was considered Exhibit 16, as me and Detective Markowitz just discussed. And second of all, I would argue that it is not a reasonable inference that there was no other evidence pointing towards Blair Rollins. That is simply making up material facts in this case.
Thank you. Since this is a procedural issue, I just want to remind our scoring panelists that you will be the sole arbiters of this particular dispute based on your own individual observations, good faith judgment, and consistent with the intent of the judicial process. You can decide either A, there was no extrapolation, or B, the statement was not an unfair extrapolation as it was not material, or C, that it was in fact unfair extrapolation as it was material. That ultimate decision is in the discretion of each of the scoring panelists, and consistently with your decision, you may award one or more points, or deduct one or more points, or take no action at all with respect to the parties involved. If you determine there was no unfair extrapolation, you can also deduct one or more points from the objecting party if you believe that objection was not made in good faith or was improvident or was poor sportsmanship. Ultimately, though, that's your decision, and your decision is final. For both counsel, thank you for indulging me with that. We'll turn it back over in terms of the process. And counsel, you may continue with your redirect.
Detective Markowitz, did you consider Blair Rollins a suspect?
Yes, sir, I did, at the start of the case.
And other than his house being in the cell tower region, was there any other evidence that led to you thinking she was a suspect?
No, sir, there was not. Actually, other than the fact that Blair Rollins was his father's attorney. That was it.
That's it. Your Honor,
sir.
Detective. Your Honor, I have no further questions.
And Ms. Hayden, do you object to this witness stepping down, or did you have any follow-up?
Fine by me, Your Honor.
Thank you very much, Detective. You're free to step down. The prosecution may call its second witness.
Thank you, Your Honor.
Yes, Your Honor. The people call Kyle Kuzak to the stand.
Ms. Proctor, thank you. And Mr. Kuzak, you've actually previously been sworn in terms of being a witness, so I won't swear you back in. I'll turn this over to the attorneys. And Ms. Proctor, when you're ready, you may inquire.
Mr. Kuzak, good morning, good afternoon, Mr. Kuzak.
Good afternoon, Ms. Proctor.
My name is Madeline Proctor. Please introduce yourself to the jury.
I am Kyle Kuzak, last name spelled K-U-Z-A-K.
Mr. Kuzak, what do you do for a living?
I am a Colorado Bureau of Investigation certified crime scene reconstruction investigator. For simplicity's sake, we're known as CSRs.
And what does being a CSR entail?
It's actually a very interesting job, Ms. Proctor. CSRs like me rely on specialized knowledge in fields like biology when looking at bodies or blood cast-off, and physics and ballistics when looking at bullet holes or shell casings. I use this specialized knowledge to help the police put together evidence from potential crime scenes.
What do you mean by potential crime scenes?
I very deliberately use the word potential because the evidence doesn't always point to a crime. What may at first look like a crime scene might actually be the result of a fatal accident where no crime was committed.
So what sort of crime scenes do you typically work on?
Well, I'd actually say there's no one type of crime scene I typically work on. I've handled a multiplicity of cases, everything from property crimes like home invasions and burglaries to violent crimes like homicides, domestic violence cases, and armed robberies.
Mr. Kuzak, when you're doing your reconstructions, who do you work for?
Currently, I'm with the Denver Police Department as a civilian employee. I've been working with them for the past 3 years.
Were you working for anyone else before that?
Yes, actually, I have over 19 years of experience as a CSR, working for different departments throughout Colorado.
Your Honor, at this time, the people request the court to recognize Kyle Kuzak as an expert in the field of crime scene reconstruction. Pursuant to Rule 702, his skill, knowledge, experience, education, and training have all been shown, and his testimony will assist the jury in understanding the facts of today's case.
Ms. Murphy, did you have any objection or voir dire?
No, Your Honor, I have no voir dire at this time. However, I will address the witness's shortcomings on cross.
All right, since that's an issue of weight, then he may offer opinion testimony pursuant to Rule 702, and you may proceed.
Yes, Your Honor. Mr. Kuzak, is there a method that you follow in your reconstructions?
Yes, I, along with all other experts in my field, use a tried and true 5-step process.
Tell us about those 5 steps.
The process is primarily centered around analysis of evidence. In step 1, reconstruction, I map out the basic facts of any case, as well as the witnesses involved. In step 2, collection, I work alongside the police to find evidence. For step 3, analysis, I use this evidence to find probable event segments using a scientific process. In step 4, I use those aforementioned event segments to test out broader theories of the case. And then, of course, in step 5, I actually reconstruct the crime scene.
Let's talk about how you applied that method to this case. How did you map out the evidence in this case?
For step 1, recognition, I didn't just map out the evidence, I also mapped out the evidence ID numbers for ease of accessibility and information about the different witnesses, so as to better understand the weight of the evidence.
What about step 2?
That would be collection. I visited the crime scene on the day of the murder after it was reviewed by the police. Later, Detective Markowitz also sent me all the evidence the police used in their own independent investigation.
And how did you analyze that evidence?
I analyzed that evidence by expanding the organizational framework from step 1 and using a scientific process, Bevel and Gardner's 7-step method to construct probable event segments.
All right, let's talk about how that's relevant today. What evidence did you use in your reconstruction?
There was a lot of evidence all throughout the bottom story of the house. Firstly, by the back door, there were scuff marks and a knocked over chair. In the kitchen, there was a knife block with a knife missing, as well as an open knife drawer and a broken plate. As I moved further through the residence, I saw blood cast off on the walls and ceiling. And then near the front door, there was Mr. Brackman's body and a bloody knife.
All right, let's walk through your reconstructive process a little bit. You started with the victim's body and the bloody knife. What did that evidence tell you?
In combination, these two pieces of evidence showed me three important facts about today's case, namely that Mr. Brackman was stabbed, that he died of exsanguination after he removed a knife from his back, and that the knife found near the body was used to kill him.
Do you know where that knife came from?
It is my conclusion that the knife came from a knife block. However, I admit it is also a possibility that it came from the open knife drawer.
Why would you conclude it came from the block?
The handle would have been very prominent in the block. It would have been easily accessible, and there was an open slot in the block for a chef's knife. And the knife found near Mr. Brackman's body was a chef's knife that would have fit the slot perfectly.
Mr. Kuzak, does it matter whether the knife came from the block or the drawer?
I'm very meticulous about my reconstruction, so it does matter to me. However, it doesn't matter to my ultimate conclusion.
Why doesn't it matter to your ultimate conclusion?
Because either way, the knife came from inside the house. The intruder did not carry the knife in. This again reinforced my conclusion that this was a burglary gone wrong and not something more sinister.
All right, Mr. Kuzak, so now we're in the kitchen. What evidence did you find there?
Aside from the open knife drawer and a knife block, there was a knocked over chair, a broken plate, and scuff marks near the back door.
What did that evidence tell you?
Independently, these pieces of evidence didn't tell me much. However, in combination, they reveal that an altercation had occurred between Mr. Brackman and the intruder.
Tell us about that altercation.
Mr. Brackman attempted to stop the intruder from entering the household, creating the scuff marks on the floor. As he fought with the intruder, they moved throughout the kitchen, knocking over the chair and breaking the plate on the floor.
All right, Mr. Kuzak, you also said you received some evidence from the police. What was that?
I did. Specifically, I received footage from the free Ring security cameras around the property from Detective Markowitz.
What did the Ring video system show you?
They showed me the height and build of the intruder's progression around the house, and the fact that the intruder was even caught on camera means that it's very likely that Mr. Brackman was warned by his security system.
Mr. Kuzak, in light of all of this evidence, were you able to reach a reconstruction for today's case?
Yes, I was.
Mr. Kuzak, reconstruct March 6th for us. What happened?
An intruder walked up to the front door of Mr. Brackman's residence. Finding it to be locked, he moved around through the side gate and to the back door. It was caught on the Ring security cameras all the way. Mr. Brackman was warned, and so he grabbed a knife to defend himself, but the intruder was already in the house. They struggled, knocking over the chair, breaking the plate, and creating the scuff marks. Mr. Brackman was stabbed during the struggle, and he died of exsanguination after he pulled the knife out of his back by the front door.
You testified earlier that not all of your reconstructions result in a crime having been committed. Is that applicable here today?
No, it is not. In this case, a crime absolutely was committed. Mr. Brackman's death was the result of a burglary gone wrong.
Thank you, Mr. Kuzak. Your Honor, I have no further questions at this time.
Thank you. Is there any cross-examination?
Yes, Your Honor.
Ms. Murphy, go ahead.
Mr. Kuzak, you say that you approach crime scene reconstruction in 5 steps, correct?
Good afternoon, Ms. Murphy. Yes, I do. Every case.
Let's go through that process one by one. When you arrived at the scene to complete your recognition and documentation step, the crime lab had already processed the evidence, correct?
They had reviewed the evidence, however, they had not processed it. They didn't bring it back to the police headquarters.
But you didn't have fresh eyes on the crime scene.
I wasn't there immediately after the murder was committed, so no.
So the evidence could have been ruffled around with, and you wouldn't know because you didn't see the crime scene firsthand.
That is highly doubtful given the DPD's practices handling evidence.
However, it's possible.
Anything's possible.
The second step in your process was the collection of evidence, correct?
Yes.
However, in all your apparently meticulous work, the digital files for the photographs of the crime scene became corrupted.
They were corrupted while in the custody of the police. My work is meticulous.
But this means that the photograph evidence the jury will review today, they're not accurate depictions?
Well, there are no depictions.
I'm sorry, could you repeat that?
Yes, it's not that there aren't accurate depictions. There are no depictions currently available to the jury.
In addition to the corrupt photos, you also managed to lose images of the blood droplets and their cast-off splatter during your collection of evidence?
It would just be the blood cast-off, and I was not the one who lost them.
So someone on your team lost them?
I do not have a team. I work independently for the police as a civilian employee.
And those photos are not here today for the jury's review so they can render a fair verdict?
No, however, they didn't play a large role in my reconstruction.
But don't you think the jury should have all pieces of evidence available to them so they can make this life-altering decision for Ms. Becker?
All pieces of evidence relevant to forming a conclusion.
The third step in this process was the evaluation of evidence, correct?
Yes.
And in this process, you analyzed the scuff marks in Mr. Brackman's home?
I analyzed them in conjunction with other pieces of physical evidence, like the broken plate and a knocked over chair.
And in your evaluation, you determined that this evidence indicated a fight between the intruder and Mr. Brackman.
Yes, again, given the totality of the evidence at the scene, it did.
And you would never make assumptions without evidence, correct?
Of course not.
Yet you assume these scuff marks indicated a fight when they could have been created at any point, correct?
Miss Murphy, I made that conclusion with other evidence, with the other physical evidence of the knocked over chair and the broken plate, which linked this to an altercation.
But carbon dating, which is the only thing that would determine the time these scuff marks were created, was not possible, correct?
No, you don't carbon date scuff marks.
So for all we know, those scuff marks could have been created a year ago when Mr. Brackman just came back from a hike because we don't definitively know the date these scuff marks were created.
We don't definitively absolutely know, but again, given the rest of the evidence, which I meticulously analyzed, that is a reasonable conclusion.
Secondly, in your evaluation of evidence, you determined that the Ring doorbell notified Mr. Brackman of the intruder.
Again, given all the physical evidence present, yes, I believe it did.
Yet again, you assumed Mr. Brackman had his notifications turned on when they very well might have been turned off.
I did not assume this. Mr. Brackman had time to open a knife drawer and then grab a knife from the knife lock. This clearly indicates advance warning.
But that's an assumption. You don't know.
It's an assumption I do know, and crime scene reconstruction works on making assumptions from the evidence.
And you didn't even take the time to confirm your theory by checking Mr. Brackman's Ring doorbell notifications, did you?
I am not a forensic data recovery specialist, so no.
Then your fourth step was hypothesis and testing, and then your fifth was reconstruction, correct?
That is correct, Ms. Murphy.
Objection compound, Your Honor.
Any response?
I can break that up, Your Honor.
All right, you can rephrase.
Then your fourth step was hypothesis and testing, correct?
Yes, it was.
And then your fifth was reconstruction?
Yes.
Now you say that after completing these steps, that the evidence you collected could only lead you to one conclusion.
It did only lead me to one conclusion.
So you must have known this case for sure if it led you to a solitary conclusion.
I knew it as well as I know the majority of my cases.
Just like you were absolutely confident in your recollection of lost and corrupted photographs?
I didn't use my recollection in my investigation. I used the photographs when I had them.
And just like you were absolutely confident in your analysis of the Ring doorbell notifications?
Ms. Murphy, given the rest of the physical evidence at the scene, I am absolutely confident in that assumption.
And just like you are absolutely confident in your analysis of the scuff marks?
Again, given the rest of the physical evidence present, I am absolutely confident.
Thank you, Your Honor. No further questions.
Thank you. Is there any redirect?
Yes, Your Honor. Mr. Cusack, was there any evidence outside of the blood splatter and the scuff marks which led you to believe there was a struggle in this case?
Yes, of course. As I have previously testified, there was a knocked over chair, the open knife drawer, the knife lock of knife missing, the broken plate, and Mr. Brackman's body. He had been stabbed.
Thank you, Mr. Cusack. Your Honor, I have no further questions.
Thank you. Ms. Murphy, any objection to this witness being excused?
No, Your Honor.
Mr. Cusack, thank you very much. You're free to step down, and the prosecution may call its third witness.
Your Honor, the people call Alex Cifuentes to the stand.
Ms. Cifuentes, thank you very much. And I'll make sure we have crossing counsel. With that, thank you. Ms. Cifuentes, we've already sworn you in, so I'll turn this over to the attorneys. Ms. Sayers, when you're ready, you may inquire.
Good afternoon, Ms. Cifuentes. My name is Feliciana Sayers. Please introduce yourself to the jury.
Good afternoon. I am Alex Cifuentes. That's Sifuentes.
Let's start with Avery Becker. How do you know her?
Avery and I, we were really good friends. We were actually on the mock trial team together, specifically the A team at CHS. And she actually got me to join when I was a freshman.
Mr. Fuentes, what is mock trial?
Mock trial is so much fun. It's like a bunch of nerds hanging out. You have a team and some people are lawyers, others are witnesses, and we go to a real courthouse with a real judge and try the case. Unless you're in a global pandemic, then you go to Zoom.
That sounds like a lot of fun, Mr. Fuentes. How did Miss Becker fit into your mock trial team?
Avery was a lawyer and sometimes a witness, but she constantly showed up late and unprepared.
How did this affect your team?
It caused us all a lot of anxiety, especially going into important tournaments like regionals.
Let's talk about Coach Mackenzie Brackman. Who was he to you?
Coach Brackman was an amazing coach. We both believed that working hard was the way to succeed. I actually think he saw a bit of himself in me at times. It's really sad knowing that he's gone. I just really miss him.
Mr. Fuentes, I understand this is hard for you, but we need to continue. What was Coach Brackman and Miss Becker's relationship like?
It wasn't the best, to say the least. There was just a lot of tension and they would argue almost every practice.
What were some of those arguments?
Most of the time it was over minor things, like when Avery showed up late, but the first big argument was when Avery showed up late for like the millionth time. Like, what was she doing? Getting Starbucks? But Coach had it. He demoted her to B team.
Was Miss Becker ever reinstated on the A team?
Yeah, when her sidekick Taylor Perkins quit.
Who is Taylor Perkins?
You know Batman and Robin? Well, Taylor's Avery's Robin. He's just the sidekick. She's just the sidekick. My apologies.
Were there any other incidents between Coach Brackman and Miss Becker that you can recall?
Yeah, actually, after the regional tournament, Coach was just debriefing us, telling us how we could be better going into state. And it was Avery's turn. And Coach started telling her that you need to be more prepared, that what you were doing could be considered malpractice in the real world. And Avery blew up and stormed off.
What did Miss Becker do after she stormed out?
She took a marker and wrote Worst Attorney Award on Coach's car.
What was Coach Brackman's response?
He kicked her off the team, of course. Vandalism is a punishable offense in court. Of course, the mock trial team would have some issues with it.
Objection, Your Honor, lack of personal knowledge. I ask that this witness not testify to the law, as it has not been established that she knows much about it.
Any response by Ms. Sayers?
Yes, Your Honor. Mr. Fuentes was a member of the mock trial team for 3 years. She understands the law. She was on mock trial with her coach, Mackenzie Brackman, who told them stories about his place as a defense attorney. She understands that vandalism is illegal, as that is fairly common knowledge.
And then Ms. Fakes, any reply?
Yes, Your Honor. This witness still cannot testify to the legalities of writing on someone's car or vandalism and what that ensues. And I ask that this witness stays away from testifying on that.
All right. Primarily focused apparently on the opinion or knowledge issue of it. Certainly she's not an expert in that regard. And ultimately, what I'd find is primarily under Rule 403, I don't think it would assist the jury in making that determination if it's common knowledge. And I don't think the relevance in terms of whether it was legal or illegal is an important fact in the case. There's a risk of unfair prejudice in that regard. And so I will sustain the objection just as to that one portion. The jury will disregard the issue in terms of the legality of vandalism, but the rest of the answer stands. And Ms. Sayers, you may continue.
Thank you, Your Honor.
Mr. Fuentes, let's talk about the text messages you received. How do you know that Ms. Becker sent them?
Avery and I were good friends. We texted all the time. It was my phone. Avery's name was at the top, and she starts off the text message with, "Hey, Alex, it's Avery."
What did you do with these text messages when you received them?
At first, I didn't do anything. I just thought it was another one of Avery's tantrums. But when I realized how important they were, and once Coach died, I gave them to the proper authorities.
Who were those proper authorities?
Detective Markowitz.
What did Detective Markowitz do with the text messages?
Well, based off
Objection, Your Honor, lack of personal knowledge.
Any response?
Your Honor, if allowed to testify, Ms. Cifuentes will testify as to what Detective Markowitz testified to earlier today, and she is going to testify about what Detective Markowitz gave her, what happened between her and Detective Markowitz in their interactions.
If the testimony is just going between what she saw between interactions, Ms. Fakes, any response?
No, I just ask that the witness stay with what she knows and not what detective might have done outside of her knowledge.
At this point, I'll overrule given the offer of proof. If the witness goes outside of something she could have observed, I'll let you re-raise the objection. But with that, Ms. Fuentes may answer the question.
Thank you.
What did Detective Markowitz do with those text messages?
Well, after listening to his testimony today, it sounds like he used them as part of his investigation.
Did he reach out to you for anything?
Well, he called me and talked about some things pertaining to the case, and he invited me to an interview.
What happened at that interview?
Well, he started off again asking me some questions about the case, and he later asked for my phone, which I left at my house. Its battery's not the best. I left it plugged into the wall. I offered to get it, but he said screenshots were fine, so I sent those to him the next day.
Your Honor, at this time, I request that Mr. Powell pull up Exhibit 14 as it has been previously admitted.
All right, he may do so. There we go.
Mr. Fuentes, let's talk about the content of these text messages. Did any of them stand out to you in particular?
Yes, if you go to Avery's fourth text message down, yes, that one, she makes a direct threat at Coach saying, well, if he's upset about his car, then he's going to be really upset when he sees what I do to his house.
Were there any other text messages that Ms. Becker sent that seemed like she was telling you a plan?
Yes, the next text message below that by Avery, yes, that one. It seems like she's making a plan saying, I'm going to wait until he's at work, then break in and trash it.
Thank you, Mr. Fuentes. Your Honor, I have no further questions at this time.
Ms. Fakes, any cross-examination?
Yes, Your Honor. Thank you.
You may proceed.
Good afternoon, Ms. Cifuentes.
Good afternoon.
I'd first like to draw your attention to the day Detective Markowitz brought you in to interview.
Okay.
Now, on the phone, you and the detective spoke about the text messages that you received from Avery.
Yes, I brought them up.
And Detective Markowitz had you go to the station to interview about the text messages?
Yeah, and some other stuff too, but yeah.
On your way to the police station to interview about the text messages, you forgot your phone, didn't you?
Its battery is just not it. I left it plugged into the wall, silly me. But I offered to get it, and he said screenshots were fine because that's what he needed.
And these screenshots the detective accepted were directly from you?
Of course they were.
The detective didn't ever try to physically retrieve your phone?
He didn't need to. He had the screenshots.
So that's a no?
No, he did not attempt to retrieve the phone because he already had what he needed.
And this phone is no longer in your possession, is it?
No, I had to trade it in. I bet it's in some Apple warehouse in Silicon Valley.
This phone is not here in court today?
Nope. But the text messages are,
now
and the screenshots.
Sure. Now, you didn't provide the detective with these texts until a day after your meeting with them?
Yep.
So that means you had an entire day to forge this purported text exchange?
Objection, Your Honor. Speculation.
Your response is to speculation.
Your Honor, this is cross-examination. I asked for some leeway on my questions.
Any reply?
Your Honor, counsel is testifying for Ms. Cifuentes. There is no evidence that these texts were forged, and she is trying to get Ms. Cifuentes to testify that she forged them when there is no evidence of that, nor were they forged.
I'll allow that to be the subject of the redirect. I find it's not calling for speculation as to whether she had the day or the time. Certainly, I'll allow Ms. Sayers to follow up in terms of that explanation, but the objection is overruled. Ms. Fakes, you may ask the question.
Thank you. I will re-ask my question. So that means that you had an entire day to forge this purported text exchange?
I wouldn't say it was an entire 24 hours because I sent them the next day. So I would say it was a couple of hours. I don't remember the exact time, but yeah, it was the next day after the interview.
Thank you. Your Honor, may my opposing counsel share Exhibit 14?
And are you asking, either way, it's up. Exhibit 14 is up. You may proceed.
Thank you, Your Honor. Now, in the supposed screenshots, the first quote unquote text from Avery states, "Hey, Alex, it's Avery," doesn't it?
It does.
Now, you've been on the mock trial scene with Avery all 3 years, isn't that correct?
Yes, I have.
And you claim that Avery is your friend?
She is my friend, or was my friend until certain things happened.
You claim that she was your best friend.
Say we were almost best friends.
And yet it is your statement here today that you claimed she was your best friend.
I said we were almost best friends. I also said we were good friends.
Sure. Now, in the screenshots, she begins her text by introducing who she is. Your best friend does?
She does. Don't you?
To clarify, Ms. Cifuentes, it's common practice to introduce yourself to your best friend every time you text.
Of course it is. Isn't it?
Thank you.
Isn't it common practice to introduce yourself to people?
Thank you, Ms. Cifuentes. Ms. Johnson, you can stop screen sharing. I'd like to move on, Ms. Cifuentes, to the day you ran into Avery at the Fry Shack, March 5th, after she got kicked off the team. You had Avery's phone in your possession. Yes?
Yeah, we did run into each other.
You played a game on Avery's phone?
Among Us. Highly recommend. It's so much fun.
So you had Avery's phone in your possession?
Yeah, she saw me.
You had access to her phone the night before the murder of Mr. Brackman?
Was playing Among Us in Avery's plain sight. Like that thing was like a third kidney to her, as Taylor Price say. He used to say, she used to say that.
Yes, Ms. Cifuentes?
Yes.
And you are aware that this phone is now missing?
I wasn't aware of that.
You are aware that.
Yes, I am now. Thank you for making me aware of that.
And you've stated in your statement that this phone is missing?
I don't, well, maybe Avery claims that. All I remember is that on that night I played Among Us and she watched me play it. I gave it back to her and I went on my way.
That is your statement here today, that you gave the phone back to her?
She saw me playing it the entire time.
So no, that is not your statement that you gave the phone back to her.
Excuse me, I must have, the very least left on the table. I did not take it with me, if that's what you're insinuating. I did not. I have my own phone for that.
I'd like to move on, Ms. Cifuentes. You know Blair Rollins, don't you?
I do. I believe he attends CHS.
Now, Detective Markowitz never asked you about Blair Rollins, did he?
Not really. Me and Blair aren't really good friends, so why would he?
Detective Markowitz never asked you about any other suspect?
He asked me about Avery. I guess that's what the evidence was leading to.
So Detective Markowitz never asked you about any other person on the mock team or at school besides Avery Becker?
Would it make sense for him to ask about really anyone else? Because
That wasn't my question. Ms. Cifuentes, did he ask you about anybody else?
I had the text messages, so it only made sense for him to talk about Avery, but we only talked about Avery.
Thank you, Ms. Cifuentes. Now, you are jealous of Avery's talent on the team, aren't you?
I wouldn't say I was necessarily jealous of it. I definitely think she was talented. I would say we were actually pretty equally skilled, to be honest with you.
And yet you work a lot harder than she does?
Of course I do. I want to be as best as I can be.
You practice in front of your mirrors for hours and hours on end?
That's the only way you can get better, yes.
And Avery showed up to regionals unprepared.
She did.
She won awards for her performance?
She did.
Well, you who work hours and hours on a line of questioning or memorizing a rule have nothing to show for it, do you?
Judges like different things, I guess. They can't see what happens behind the scenes, but I'll get them next time.
You didn't think Avery deserved to be on the team, did you?
She showed up late and unprepared to practice. It's part of the main things of being on the A team, so no, I didn't.
You asked Mr. Brackman on multiple occasions why he even put up with Avery.
I could tell it was taking a toll on him. Of course I did. I was kind of concerned.
Yeah, you yourself said you were happy she was off the team.
Well, it was causing the team a lot of anxiety. So yes.
You were elated for the bigger role that you would have at state?
It's kind of sad that it was my friend's role that I took, but I was excited for my chance to perform and support my team.
And you even seem quite elated to be here testifying today.
This is my first time ever testifying in court. I, of course, did mock trial. This is kind of cool.
So you have a reason for Avery to be off the team for good?
I would say not exactly. I still advocated to coach to get her back on the team because you can't replace her for state. So we needed her back on the team.
And yet you were excited for the bigger role you would have?
I think anyone's excited for a bigger role.
Thank you, Ms. Fuentes.
Avery's.
No further questions, Your Honor.
Was there any redirect examination?
Yes, Your Honor. Ms. Fuentes, let's talk about that police interview. What happened when you realized your phone was missing?
Well, I offered to go get it. I offered to go get it, but again, Detective Markowitz said screenshots were fine.
Did you send those screenshots?
Yes, I did.
Ms. Fuentes, did you in any way forge those screenshots?
Of course not.
Now, Ms. Fuentes, what is your relationship with Avery Becker?
Avery and I, we were really good friends. We were almost best friends, as I said earlier. But after everything that happened with Coach, I can't be friends with someone who I believe killed him.
Thank you, Ms. Fuentes. Your Honor, I have no further questions at this time.
All right. Any objection to this witness being released?
No,
All right.
Your Honor.
Ms. Fuentes, thank you very much. You're free to step down. Does prosecution have any additional witnesses?
No, Your Honor, the prosecution rests.
All right, and then we'll move to the defense presentation in chief. Is the defense ready to call its first witness?
Yes, Your Honor. The defense calls Professor Blake Van Owen to the stand.
Thank you. Professor Van Owen, you have previously been sworn as a witness, so I'll turn this over to the attorneys. And Ms. Murphy, when you're ready, you may inquire.
Good evening, Professor Van Owen. Would you please state your full name and spell your last for the record?
Hello, I'm Professor Blake Van Owen, Vanowen.
And what do you do for a living?
I've worked for the Aurora PD as a school resource officer, and now I'm a professor. My journeys have led me to a community college, and now I work at CU.
And where'd you receive your education?
I received my bachelor's in English right here in Colorado at Boulder, and my master's in criminal justice from Ashford University.
You mentioned you're a professor. What do you teach?
Oh, everything, ranging from police procedures, police practices, and most importantly, social justice.
Have you ever used your experience to testify as an expert witness?
Absolutely. I avail myself regularly as an expert courtroom witness. I've consulted on over 100 cases thus far. I've also been admitted as an expert for courts in 6 different states. I get to use my expertise everywhere from the canyons to the Rockies.
What areas have you testified to as an expert witness?
I testify to crime scene reconstruction, cell tower analysis, and general police practices.
And how many times have you testified in each of these areas?
Yeah, so let me break that down. Crime scene reconstruction 8 times, cell tower analysis 5 times, and general police investigation 12 times.
What are the methods that you use to determine the facts of a case?
Anything, ranging from police reports, crime scene reconstruction, and cell tower reports.
Did you use these methods and your prior expertise to conclude your investigation in today's case?
I absolutely did. It's like you're talking to a beekeeper about bee care, honey extraction, and hive construction. This case is really the wheelhouse of my expertise.
Your Honor, because of Professor Van Owen's extensive experience as a defense expert, we would like to enter Professor Van Owen in as an expert witness in crime scene reconstruction, cell tower analysis, and general police practices pursuant to Rule 702.
Is there any objection or voir dire?
No objection to Professor Van Owen testifying in those fields.
All right, she may offer opinion testimony pursuant to Rule 702 in those areas. And with that, Ms. Murphy, you may resume.
Professor Van Owen, have you reviewed the police's opinion in today's case?
I certainly have, backwards and forwards.
And do you agree with their opinion?
I disagree wholeheartedly. Numerous areas were either overlooked or completely botched.
Which areas in the investigation were overlooked?
Well, I've organized their flaws into 3 categories: the attack, the opportunity of the intruder, and the carelessness in the collection of evidence.
Let's look further into those points. First, could you start with the attack?
Certainly. The police believe that the victim anticipated the intruder's attack, and there was a sort of struggle between the two. This was based on, get this, Ring doorbell alerts and scuff marks on the floor.
Were these reliable indicators?
Absolutely not. The police failed to see if the victim even had Ring alerts. It was a very simple check, but the police just assumed they were on. It's very likely they were turned off.
You also mentioned the scuff marks. Could you elaborate to those a little bit more?
Yeah, the police never even dated the scuff marks. They have no idea when they were made or what they are from. Without this information, they are just scuff marks of doubt.
In lieu of this information, what did you find to be the most likely scenario?
The victim was clearly sitting at the table, unaware of the intruder. The intruder stabbed him from behind and fled the scene.
The second point that you mentioned was the opportunity of the intruder. Why did you find the police overlooked this area?
To start, the height of the intruder was entirely disregarded.
Why does the height matter?
If you look at the photos, the victim was clearly a large, full-grown man. For the prosecution's theory to work, the intruder would have to be standing above him to stab at that downward angle. Avery, while the victim was upright, could clearly not stab a full-grown man.
Were there any other details in this area that the police miscalculated?
Yes, the police relied on the unpredictable cell tower reports.
Why are they unpredictable?
Think of a cell tower like a glass of water, filling up a glass of water. When one glass gets too full, you move on to the next. Same goes for cell phones. When one tower doesn't provide the best signal, it moves on to the next. This connection is practically impossible to predict. A phone could sit under a sofa for hours and connect to several different towers.
And why is the cell tower information crucial?
The police once again assumed that the map could show the location of Avery. But as I said, cell towers don't work like a GPS, and phone GPS data was not provided by the police.
The third and final point you mentioned was the carelessness in the collection of evidence. Can you elaborate?
On top of everything, photos of supposed blood drops around the house were corrupted. The police entirely lost a set of evidence from the crime scene.
Is there any other information that the police did not investigate?
The police failed entirely to consider other suspects, specifically Blair Rollins.
Who's Blair Rollins?
Blair is a former CHS student. Her father was sent to jail after the victim represented him in trial.
Was Blair questioned by the police?
Blair was not questioned by the police. Let me say that again. Blair, someone with a clear motive against the victim, was not located or questioned by the police.
Overall, What were your conclusions about the police's investigation?
Simply put, the police have no files, no phone, and no felony. This investigation was rushed, and Avery Becker has been wrongfully accused.
And why are the 3 key details that we discussed today so important?
These points are the foundation of the prosecution's case. They're as pivotal as the axle of your car when you're going 90 miles an hour. If you're going to put someone on trial for murder, it is your burden to prove every single detail correct. The details of the prosecution are just far from correct.
Thank you, Professor Van Owen. No further questions, Your Honor.
Thank you. Is there any cross-examination?
Yes, Your Honor. Good afternoon, Professor. My name is Sean.
Good afternoon, Mr. Powell.
Let's talk about the screenshots. You believe
Absolutely.
You believe the screenshots were doctored?
The screenshots were doctored. If you don't mind, I'd love to pull just a version of Exhibit 14 in front of me. Very visual person. Yes, I do believe these screenshots were doctored.
And you believe that because they're screenshots?
They are not only just screenshots, they are screenshots that were not verified by the police in any way today.
But you can admit that nothing on the screenshots actually shows that they were doctored. Isn't that true?
I'm not an expert in Apple iMessaging or screenshots. However, no, there doesn't appear to be anything blatant standing out about this.
All right. Let's talk about the photos of the blood spatter. You admit that these would have shed no light on who killed Mr. Brackman.
They shed no light on the death of Mr. Brackman. They only shed light on the police's failed investigation.
So that's a yes, they would have shed no light.
Yes, they would have shed no light on the particular murder of Mr. Brackman. No.
And Professor Van Owen, you also admit that no one should attribute any malice to these corruptions.
No, not particularly.
All right, let's talk about Blair Rollins. You believe
Absolutely.
Blair Rollins had a motive?
Absolutely.
That's because Mr. Brackman tried to defend Jonathan Rollins.
Absolutely. Your father being sent to prison is far greater reason than getting kicked off an extracurricular team.
Professor Van Owen, I understand that you would like to explain your answer. My question didn't call for an explanation, and if Ms. Murphy thinks it's necessary, she can ask. My question was, you believe that because Mr. Brackman represented her father? Your answer is yes.
Yes.
And Jonathan Rollins yelled something to Mr. Brackman during the sentencing period of the trial.
Yes, he did. Thank you so much for bringing that up.
You say that Jonathan Rollins yelled out, "Brackman is going to die," right?
He did. Yes.
Right. And now you've heard Exhibit 22.
I have, yes. It was part of my partial investigation.
Partial investigation. And Exhibit 22 is a fair and accurate copy of the report.
Yes, it is. I believe so. Let me pull it up. Oh, yes, absolutely. Accurate.
The people request that Exhibit 22 be admitted to evidence, where its accuracy has been shown and its authenticity has been stipulated to.
Any objection to Exhibit 22?
No, Your Honor.
Exhibit 22 is admitted.
Your Honor, permission for Ms. Sayers to play Exhibit 22.
She may.
I'll get you back, Brackman, if it's the last thing I do.
Professor Van Owen, you didn't hear Jonathan Rollins yell, "Brackman was going to die," was it?
In that particular statement, no, I did not. However, this was at another time in the trial.
Is it your testimony today that Jonathan Rollins did yell, "Brackman is going to die" in a different part of the trial?
No, my apologies. Let me rephrase. Since we're focusing on Exhibit 22, I'll re-clarify. This is the exact statement stated from Jonathan Rollins. Yes.
Right, and you don't hear Jonathan Rollins yell, Brackman is going to die, do you?
No, I hear him yell, I will get back at you, Brackman, if that is the last thing I do.
And you spoke to Blair Rollins about this supposed motive, right?
I'm sorry, did you ask if I spoke to Blair Rollins?
That was my question.
Yes, I did.
Your testimony today that you did testify that you did speak to Blair Rollins?
My apologies. I observed the Blair Rollins in the courtroom. No, I did not speak personally.
Blair Rollins is in the courtroom today?
In the courtroom from that prior hearing that I retrieved this statement from.
So is it your testimony today that you were at that hearing?
No, I reviewed that hearing.
Oh, and you could hear Ms. Rollins in that statement?
No, I could not hear Ms. Rollins in that statement. However, I reviewed the trial and was able to conclude that.
Professor Van Allen, once again, I understand that you would like to explain your answers. If Ms. Murphy would like to do that, we can ask you to do that. Professor Van Allen, you spoke with Jonathan Rollins about this, right?
Yes.
Is it your testimony today that you spoke with Jonathan Rollins about the supposed motive?
No, sorry, let me clarify. I did not speak to Jonathan Rollins specifically. I reviewed the courtroom testimony and have come to my conclusions based on that.
So you did not speak with anyone about Blair Rollins' alleged motive?
I didn't speak to Jonathan Rollins as he is in jail or Blair Rollins as he has not been located. No.
So the only motive or evidence of this alleged motive comes from a recording from Blair Rollins' father.
I provided that testimony here in court today. However, it was from the entire hearing and other evidence I'm happy to provide.
That wasn't my question. The only evidence of Blair Rollins' motive comes from Mr. Brackman defending her father and the statement made by Jonathan Rollins.
Correct. Yes, I'd consider this enough evidence.
All right, let's talk about the knife. You believe the knife was brought into the home by the intruder?
The knife was brought into the home, yes.
Well, you saw the ring videos, didn't you?
I did, yes.
And you saw the intruder in that video?
I did, yes, masked and gloved.
Right. And you didn't see the intruder carrying a knife?
No, I could not visibly see them carrying a knife. However, it could have been anywhere on their person.
So you mean to tell us that somebody pocketed or put a 7.5-inch blade in their pocket or waistband?
Yeah, I don't know many people who would want to approach a house with a knife that large.
Exactly. Thank you, Professor. Your Honor, I have no further questions at this time.
Was there any redirect?
Yes, Your Honor, briefly. Professor Van Owen, why is Blair Rollins a more probable suspect?
Blair Rollins' father was sent to jail because of Mackenzie Brackman. Blair was not at school on the day of the murder, and Blair has not been located since, and she was not even questioned by the police.
And why is Exhibit 22 that we just discussed such a crucial piece of evidence?
It says, I will get back at you, Brackman, if it is the last thing I do. I think it speaks for itself.
Thank you, Professor Van Owen. No further questions, Your Honor.
Mr. Powell, any objection to releasing this witness?
No objection, Your Honor.
Thank you. Professor Van Owen, thank you. You may step down. The defense may call its second witness.
Yes, Your Honor. The defense calls the defendant, Avery Becker, to the stand.
Ms. Becker, thank you very much. You've previously been sworn, so I will turn this over to the attorneys. And Ms. Hayden, when you're ready, you may inquire.
Thank you, Your Honor. Good afternoon, Ms. Becker. Please state your full name and spell your last for the record.
Avery Becker, Becker.
Avery, how do you know Mr. Brackman?
Mr. Brackman was my mock trial coach while I was a student at Colorado High School.
And what was your relationship like with him?
Unfortunately, it wasn't great. I loved mock trial and I was good at it too, but Mr. Brockman always seemed to think that I was lazy just because I didn't need to prepare all that much.
So would you say that Mr. Brackman was a good coach?
In my opinion, not really. Mr. Brackman was always very controlling and demeaning. He would rewrite most of the students' work anyways, and then just spend half the practice talking about himself or his Porsche.
Before we move on, Ms. Becker, could you please inform the jury of your relationship with Taylor Perkins?
Taylor Perkins is my best friend. We decided to do mock trial together as a way to get out of the house and see one another more often.
All right. Let's talk about your senior year, your last year of mock trial. How did that go?
Unfortunately, the mock trial season wasn't great. Mr. Brackman assigned me the role of doing the closing and crossing the expert witness, two roles which are both pretty big, but that didn't stop him from trying to completely take over all of my work.
So what happened before the regional competition of last year?
Yeah, about a month before the regional competition, I showed up at practice one day, only for Mr. Brackman to once again say that he didn't think I'd prepared enough. Before I could even get a word in to defend myself, he demoted me to the B team.
So what did you do?
Well, I was a little bit upset because I knew that I deserved my position on the A team. But then Taylor, who, if we're being honest, wasn't really all that into mock trial anyways, came up with the idea that if she quit the team, Mr. Brackman would be forced to let me back on A team, and luckily he was.
So your position on A team was reinstated?
Yes, it was.
And then how did the regional competition end up going?
It went amazing. Mr. Brackman put me back on the team in my original roles, and I was awarded Best Attorney and Best Closer, so it was great.
After receiving these accolades, did the way that Mr. Brackman treated you change?
Unfortunately, no. On the very next practice after regionals, Mr. Brackman was right back to his same self. He said that I didn't deserve the awards I'd won and that the team's victory was only thanks to the scripts that he had practically written and not due to our hard work. He even said that I was just lucky and only relied on my good looks to get by.
Wow. So what did you say?
Well, I just basically retorted that he couldn't keep taking credit for all of our work, and on that occasion I was pretty upset, so I actually ended up storming out of practice.
What happened when you stormed out of practice?
Yeah, when I got to the parking lot, I saw Mr. Brackman's car, and I also happened to be holding what I honestly believe to be an expo marker, as I'd been about to take notes on the whiteboard about regionals.
What did you do with that, what you believe to be an expo marker?
I did the dumbest thing I have ever done. I used what I thought to be an expo or dry erase marker to write on Mr. Brackman's car, Worst Attorney Award. I guess I just didn't think it through because I had no idea it was a permanent marker, but regardless, I just feel awful about it and I'm so ashamed of the whole incident.
How did Brackman react to this?
Well, Brackman then walked out to the parking lot. I'm pretty sure he was trying to talk to me about the argument we just had, but when he saw the car, he exploded, yelling at me that I was off the team and even calling Taylor a loser.
Wow. What happened that day when you got home, or I guess that night?
Yeah, when I got home, I was sobbing. I guess I was just so upset that my mock trial career was over for good. But I ended up talking to my mom about it. I left out the part about the Sharpie in the car, but I told her everything else, and she gave me some really great advice and helped me to realize that I should just calm down and be honest and go apologize to Mr. Brackman.
And with your mother's advice and with hindsight, how do you feel about the car incident?
So quickly, I just felt awful about the whole situation and so ashamed of what I'd done. I tried to talk to Mr. Brackman in person and I texted him. I even offered to scrub the car and said that if that didn't work, I could get a new job to pay for repainting because I felt awful about the whole thing.
So you ended up taking your mother's advice?
Absolutely, yes. She was totally right, and the best thing to do was just to go apologize.
Your Honor, hearsay. The defense is trying to offer the fact that her mother said she would apologize for the truth of the matter asserted, and that is an out-of-court statement under 801, therefore inadmissible under 802.
Any response?
The advice given by Ms. Becker's mother is not being offered for the truth of the matter asserted. We are not asserting that it is true that Ms. Becker should have apologized to Mr. Brackman. We are simply stating the effect that it had on Ms. Becker and her actions.
All right. Any reply in light of that offer?
I do believe that in context, the words that Miss Becker's mother said to her that night do affect the statements she said, on that night, and thus they are being offered for the truth of the matter asserted.
I'm going to agree. I think it's being used for the point of the effect on the listener, essentially, for the non-hearsay purpose, not to prove, for instance, something happened because a witness said it, but the fact that she was told to do that as an explanation for her actions. So although it's an out-of-court statement, I'll overrule as to hearsay, and you may continue.
Thank you, Your Honor. Was Mr. Brackman ever able to accept these many apologies?
No, Mr. Brockman refused to speak to me in person and never answered my text messages.
And let's transition. What did you do on the evening of March 5th?
Right. So on that evening, Taylor and I, we went to the Fry Shack where we saw a bunch of the other mock trial kids, including Alex Fuentes. While we were there, Alex played some games on my phone, and then afterwards, Taylor and I just went to the mall to walk around.
Could you tell me about your relationship with Alex Fuentes?
Alex Fuentes and I are not friends. We've never really gotten along too well, and we don't hang out or text or anything like that. We don't get along very well.
Back in your senior year of high school, did you and Alex text often?
Absolutely not. I heard Alex lie on the stand earlier and say that I texted her trying to get back on the team, and even that I told her I was going to trash Brackman's house. But this is absolutely not true. I have never texted Alex for any reason, and I never would, let alone to say something as awful as that.
So the texts that Ms. Fuentes brought into court, are they real?
No, they're not real at all. I never texted Alex Fuentes.
Thank you. So what happened when you woke up on the 6th?
When I woke up on the 6th, I immediately noticed that my phone had gone missing.
And so what did you do about it?
Well, I knew that the last time I'd seen it was probably the Fry Shack, so I picked up Taylor and we went there to look. We also checked the mall, but we kept using Taylor's phone to call mine and hear it ring, but unfortunately, every time we called it, it would hang up really quickly, leading us to believe that either maybe the battery was dead or somebody had taken it.
And were you ever able to find this phone?
No, it's still missing.
Ms. Becker, do you know who Blair Rollins is?
I do. Blair Rollins is a student who went to Colorado High School at the same time I did.
And do you know what Blair looked like?
Approximately. Blair was just about the same size and build as I was.
Did, to your knowledge, Blair Rollins know Mr. Brackman?
Blair definitely knew Mr. Brackman. Mr. Brackman was the attorney that lost the case that got Blair's dad sent to jail. And from what I noticed, Blair...
Under Rule 602, need for personal knowledge, this is speculation that no inadequate foundation has been laid of how Miss Becker would know that Blair Rollins and Coach Brackman had a relationship at all.
Any response in terms of lack of personal knowledge?
Your Honor, I asked the question very clearly to your personal knowledge, Ms. Ms. Becker, do you know of a relationship between Blair and Brackman?
And any reply from Ms. Proctor?
I still believe that inadequate foundation has been laid for the fact that she would know that.
All right. At this point, given the testimony as it's developed, although the witness has said that she is aware of that, she hasn't testified as to the basis of that knowledge. Certainly evidence to prove personal knowledge can consist of the witness's testimony, but without further foundation, I would sustain the objection as to the lack of the basis of that knowledge. So objection sustained. I'll let you either lay further foundation, or if you wanted to move to a different area, you could.
I'll lay more foundation, Your Honor. Ms. Becker, where did Blair Rollins go to high school?
Blair Rollins went to Colorado High School at the same time I did.
And how did you know that Blair knew Brackman?
Yeah, honestly, even though I don't necessarily know all the ins and outs of their relationship, it was pretty common knowledge around the school about the big incident between them.
So it was your knowledge that Brackman lost the case that sent Blair's dad to jail?
Yes, as far as I know, that's the case.
I'm sorry, was there an objection? It broke up.
I said leading.
Oh, I'll sustain at this point. It did suggest the answer would begin with so. With that, Ms. Hayden, if I could have you rephrase that question.
I will, Your Honor. Ms. Becker, how do you You know that Blair knew Brackman.
Well, honestly, I mean, they both were people who I knew through the school. You know, Blair went to the school and Mr. Brackman was my mock trial coach. And then from what I noticed, it was pretty common knowledge around the school that about the big incident between the two, that Mr. Brackman was the attorney that lost the case that got Blair's dad sent to jail.
Thank you, Your Honor. No further questions.
Thank you. Was there any cross-examination?
Yes, Your Honor. Good afternoon, Ms. Becker.
Good afternoon.
My name is Madeline Proctor. Let's start with the mock trial team. You thought you were the best attorney on the entire team.
I suppose in some ways you could say that. I did really love mock trial. It was something I was good at.
Is it your testimony here today that in some ways you could say you were the best attorney on the entire team, or that you thought you were the best attorney on the entire team?
Objection, Your Honor. I ask that Ms. Proctor give my witness some latitude. She's here on trial for murder.
And in what sense, what was the area you were concerned that she was not giving her sufficient latitude?
I believe that Ms. Proctor is now attempting to impeach my witness for her choice of words.
First, any response, Ms. Proctor?
I'm simply trying to clarify Ms. Becker's statement here today. I agree this is a very important consideration today of whether or not she is guilty of first-degree murder. So I would like to make sure that her statements are indeed factual.
At this point, since it's cross-examination, I'll allow you to ask the question. Ms. Hayden, I'll let you address it on redirect. If it goes too far in terms of badgering or something along those lines, I'd ask that you reassert the objection and we'll go from there. But presently it's overruled. You may ask the question.
I'll ask again, Ms. Becker. You thought you were the best attorney on the entire mock trial team.
As I had just said, yes, I love mock trial and it was something I was good at.
Sure, but Coach Brackman did not agree with you.
I think the thing is that Mr. Brackman and I guess you could say we just were different people when it came to that, so we did have disagreements.
Ms. Becker, that was not my question. I understand you'd like to explain, but you'll have some time for that on redirect. My question was that Coach Brackman did not agree with you that you were the best attorney on the entire team. Yes?
That would be correct.
All right, let's talk about Coach Brackman then. You thought you were a better attorney than him too.
I could say, yeah, in some ways from what I had heard about Mr. Brackman, I did feel that way.
That's a yes?
Yep.
And you thought he was the one with the ego?
At times, he certainly did have an ego. Like I said, he talked a lot about himself and his Porsche.
Right, the Porsche you're making fun of after you vandalized it?
Once again, in regards to the incident with the car, I had no idea it was a permanent marker, but that is the car I'm referring to.
Again, I understand you'd like to explain about the marker, but my question was just that is the same Porsche that you vandalized, and your answer is yes.
As I already said, yes, that is the car I'm referring to.
All right, and you two would get into arguments at almost every practice.
We did have a lot of small altercations, yes.
Let's talk about some of those. After one, you were even demoted to the B team.
That did happen, but luckily it all got sorted out and I ended up back on the A team, so it wasn't that big of a deal.
Ms. Becker, my question was that you were demoted to the B team, yes?
And as I already said, yes, but I ended up back on the A team.
And so that was a team you called a team full of losers, right?
At times, I guess I could make kind of blunt statements, and I did say that. Like, I knew that I deserved my spot on the A team.
Ms. Becker, is it your testimony here today that you do not still think the B team is a team full of losers?
I never said that, but to clarify to your question, yes, I did use those words.
And you still think that?
To some extent, I guess you could say, yeah.
So you did everything you could to try and get back onto the A team?
Of course, as I've said multiple times, I love mock trial, and it was something I wanted to continue with.
Right, and none of that worked at first.
At first, yes, but it all got resolved in the end.
Right, we'll talk about that. You were taken back onto the A team after Taylor Perkins quit the team.
Well, let me just clarify first that Taylor wasn't that into mock trial, so it wasn't a big deal, but yes.
I'm not asking you about her involvement in mock trial. My question is that you were not reinstated onto the A team after until Taylor Perkins quit. Yes?
And as I already said, yes, I was reinstated after Taylor Perkins quit the team.
That's the same Taylor Perkins who you claim to be with on March 6th?
Not just claim, I was with Taylor Perkins on the 6th, and it is the same Taylor.
The only person you were allegedly with on March 6th?
I wouldn't say that. I mean, Taylor's the only person I was with all day, but I was also at the mall and the Fry Shack, which are pretty public places.
Miss Perkins, or Miss Becker, you and Miss Perkins are the only two people who will testify to this jury that you two were together.
In court today, yes. She's the person I was with all day long.
Right. All right. So then you were taken back onto the A team.
Right.
And you won some awards at the regional tournament.
I did. I won Best Attorney and Best Closer. It was really great.
Right. But Coach Brackman said you did not deserve those awards.
Yeah, he said a lot of things. He also said I was just lucky and only relied on my good looks, which I guess was sort of a compliment.
That made you mad.
Of course, it was a bit upsetting. It's hard to get a lot of criticism from your coach, someone who you might say could be a mentor.
Miss Becker, I understand you were upset, but you were also mad.
Yes, of course. Like I said, it's hard being criticized a lot.
And so you went outside.
I did go outside, yes.
And you saw that white Porsche.
I did. He talked about that car a lot. It said litigator with an 8 on the license plate.
Right, the one you knew he loved.
Yes, he talked about it a lot.
And you took a permanent marker and wrote worst attorney award on his car.
I took what I believe to be an expo marker or a dry erase marker, and then I wrote on his car. Yes, I feel awful about it.
My question is not whether or not you thought it was a permanent marker, but that it was a permanent marker and you wrote worst attorney award on his car. Yes.
And as I said, yes, I'm simply clarifying that I had no idea at the time that it was permanent, and I never should have done it regardless.
And Ms. Becker, you're the only person who can speak to your thoughts about whether or not it was a permanent marker.
I would presume so, yes.
All right, so then he kicked you off the team for good.
Yes, he came out and got pretty upset, understandably, and kicked me off.
Now you were even madder.
At the time, yes, of course. But honestly, the whole thing, it was the worst mistake of my life.
Ms. Becker, that was not my question. It was that you were even madder. Sounds like your answer is yes.
As I believe I said, yes.
And when you got home that night, you didn't tell your mother the full story.
I told her almost everything, but it's true that I left out the part about the Sharpie in the car.
That's a yes.
It is.
In fact, you blamed it on someone else.
Would you mind clarifying who you're referring to? I don't believe I directly blamed it on someone.
You blamed Coach Brackman.
I wouldn't necessarily
Objection, Your Honor.
Basis to the objection?
Vague. I believe Ms. Proctor is asking whether Avery blamed the Sharpie writing on the car on Mr. Brackman. This question is very confusing.
Your Honor, I can clarify.
If you'd like to do that, I'll let you rephrase the question.
You blamed getting kicked off the team on Coach Brackman.
I don't know that I would necessarily blame it on him. I think that I said that, he kicked me off for no reason. So in some ways, but it wasn't a direct blame or anything. And of course I was wrong about the whole situation.
All right, Ms. Becker. That night you told your mother you would get back at Coach Brackman if it was the last thing you did.
In the moment, as I was still upset, I used those words, but I quickly realized that was the wrong response.
Ms. Becker, that's not my question. My question was that night you said you would get back at Coach Brackman if it was the last thing you did. Sounds like your answer is yes.
As I already believe I answered, those were the words I used.
Thank you, Ms. Becker. Your Honor, I have no further questions at this time.
Was there any redirect?
Yes, Your Honor. Ms. Becker, what did you try and do to make up for writing on Mr. Brackman's car?
Well, I felt absolutely awful about it, so I did all kinds of things. I went to talk to him in person, I texted him, I offered to scrub the car, I even said that if that didn't work, I could get a new job to pay for repainting. I wish more than anything I just had the opportunity to make things right with him.
So after you wrote on the car, which some might call a tantrum, you made up for your actions, or attempted to, isn't that right?
Absolutely. In the heat of the moment, I made a mistake, the worst mistake of my life, but I felt awful about it and did everything I could to make things right with Mr. Brackman.
Avery, did you murder Mr. Brackman?
Absolutely not. I I had absolutely no reason to, and I just feel awful about the car incident. So I certainly did not murder Mr. Brackman.
Thank you, Your Honor. No further questions.
Ms. Proctor, any objection to releasing this witness?
No, Your Honor.
Thank you, Ms. Becker. I'll let you go ahead and step down. And the defense may call its third witness.
The defense calls Taylor Perkins to the stand.
Thank you, Ms. Perkins. Again, you've been sworn in as a witness already, so I'll turn this over to the attorneys. And Ms. Fakes, when you're ready, you may inquire.
Thank you, Your Honor. Good afternoon, Ms. Perkins. Please state your name and spell your last for the record.
Hi, I'm Taylor Perkins. That's Perkins.
Could you introduce yourself for the jury, Ms. Perkins?
Yes, of course. So as I just said, my name is Taylor Perkins. I graduated from Colorado High School last year, and now I'm a freshman at the University of Colorado in beautiful Boulder, Colorado. Go Buffs!
Could you describe your relationship with Ms. Becker?
Yeah, so Avery and I were BFFs all throughout high school. She was such a good friend that she was able to get me to join the mock trial team. And no offense, I wouldn't have necessarily done mock trial if it wasn't for Avery. Not really my thing.
Could you tell me about your involvement in mock trial?
Yeah, so I did it my senior year. I was on A team with Avery. I honestly did it to spend more time with her. Wasn't exactly committed to the team, if I'm being honest. So I mean, when she was demoted to B team, I stepped down. I really wouldn't do it without her. She made it fun.
Why was Ms. Becker devoted to B team?
Oh, it was completely ridiculous. So about a month or so before regionals last year, Avery came to practice. Unprepared, she was kind of going off script and making stuff up as she went. But in classic Avery fashion, she killed it, pulled it off. She's really a natural when it comes to mock trial. But Coach Brackman seemed to be a little upset about this, and that's when he demoted her to B team.
Do you think Ms. Becker deserved this demotion?
Oh, no, absolutely not. Avery worked so hard for mock trial, definitely A-team material. She loved it. So that's why about a week or so before the regional competition, I stepped down from the team because if I stepped down, there wouldn't be enough people on the team for the team to compete. So Coach Brackman would have had to put Avery back on the team. And it paid off. Avery won Best Attorney and Best Closing Argument at the competition. She so deserved those awards, but Brackman didn't seem to think so.
What do you mean Brackman didn't deserve the award? Didn't think she deserved the awards?
Well, there was like a practice after regionals, and Coach Brackman gave Avery a bit of a hard time about her performance, saying she didn't observe the awards.
How did Ms. Becker react to this?
Avery got pretty upset, rightfully so. I mean, she did love mock trial. She ended up writing Worst Attorney Award on the hood of Brackman's car. But to my understanding, Avery thought it was a Sharpie marker. Or sorry, God, not a Sharpie marker. Avery did not think it was a Sharpie marker. She thought it was a dry erase marker, but apparently it did turn out to be a Sharpie marker. Sorry, there's so many markers, getting them confused.
And did Ms. Becker try to fix her mistake?
Yeah, she did everything she could to talk to Coach Brackman, but he didn't seem to want to hear it. And so unfortunately, that is when he kicked her off the team.
How did Ms. Becker react to being kicked off the team?
I mean, initially, she freaked out. That girl loved mock trial. So I think she texted some people trying to strategize to get her back on the team, maybe. I think some people said that they might try to talk to Coach Brackman about it. And I think she may have texted Alex Cifuentes, but I'm not 100% sure.
Could you please describe from your observations Alex and Avery's relationship?
Yeah, so I spent a lot of time at mock trial with Alex and Avery, and they were nice to each other. They both cared about mock trial, both wanted to succeed. I wouldn't call them friends. They were amicable. But Avery was one of the best on the team, and I think that Avery got the roles that Alex seemed to have wanted. So I do think that Alex was a bit overshadowed by Avery.
To clarify, Ms. Perkins, were Avery and Alex friends?
They weren't friends, no.
Ms. Perkins, moving on, could you tell me about the night of March 5th, the day before Mr. Brackman's murder?
Yeah, so March 5th, Avery and I actually hung out that night.
What did you do?
So Avery swung by my house after school, hung out, played some games on our phones, you know, us teenagers and our phones. And then we headed over to the Fry Shack to get some food, which turned out to not be a great idea.
Why not?
Well, that's where the mock trial team actually hangs out a lot. So we did end up running into them there. I guess they were there for like a post-practice snack or something like that. But when Avery saw them, she seemed to be a little upset and stormed off to the bathroom.
Where was Avery's phone while she was in the bathroom?
It was on the table when she was in the bathroom, and then I'm not really sure if she did grab her phone again when we left.
Was anyone with you while her table was on the phone? Or while her phone was on the table?
Yeah, Alex was actually.
What happened the next morning, the day of Mr. Brackman's death?
So Avery and I have first period off together, so we'll usually drive together, you know, save some gas money. But she hadn't answered any of my texts that morning about driving together. And so when I brought that up to her, we realized that like her phone was missing. So we spent the day retracing our steps and searching for her phone.
Where did you look?
We went to the mall, checked every store that we had gone into the night before. We went to the Fry Shack. We went to the Fry Shack again to check with the afternoon shift. And the second time we went to the Fry Shack, we actually ended up running into the mock trial team again, as we always seem to do. And apparently Coach Brackman hadn't showed up to practice.
Did you try to call or text Avery's phone that day?
Yeah, we called and texted her phone several times trying to find it. You know, phones are expensive. You don't necessarily want to have to replace one. I do have an Android though, so we didn't like think to use Find My iPhone or anything like that at the time.
Did the police ever try to use your phone to check your call logs for the day?
Actually, no, they didn't.
Did the police ever try to use your phone to check your location for that day?
No.
And was Miss Becker's phone ever found?
I don't believe so.
Moving on, Miss Perkins. Do you know who Blair Rollins is?
Yeah, Blair was a kid who used to go to CHS.
How do you know this?
You know, I saw Blair sometimes in the hallway, and there was also some like stuff about Blair that everyone at the school kind of talked about.
What did you know about Blair?
Well, what I knew from school, and also as you've heard some other people mention today, Mr. Brackman was a lawyer in a case that sent Blair's dad to jail.
Was Blair at school on the day Mr. Brackman was murdered?
No.
And were you with Avery all day?
Yeah, I was with Avery all day for like 2 peas in a pod, and that pod was one pod that day.
And Miss Perkins, did Avery Becker murder Mr. Brackman?
Nope, I was with Avery all day, and we spent the whole time looking for her phone.
I have no further questions, Your Honor.
Was there any cross-examination?
Yes, Your Honor. Good afternoon, Miss Perkins. My name is Feliciana Sayers.
Hi.
Let's start with Coach Mackenzie Brackman. You thought Coach Brackman was a mediocre coach.
Yeah, he wasn't the greatest coach.
You thought he made bad choices for the team.
Yeah, occasionally.
Miss Perkins, is that a yes?
Yes, as I just said, yes.
To your knowledge, Coach Brackman thought Miss Becker put little effort into mock trial.
Based on what I observed at practice, that is how it came across.
Yet, Miss Becker would often show up late and unprepared to practice.
Avery was really a natural at mock trial, so even though she's
Perkins, that wasn't my question. My question was, Miss Becker would often show up late and unprepared to practice.
I was getting to my answer. She did show up unprepared often, but she was a natural, so in the end, she always pulled it off.
Again, Miss Perkins, that wasn't the answer to my question. My question was, Miss Becker showed up late and unprepared to practice, and your answer is yes.
As I just stated, yes.
Now let's talk about what happened a month before the regional tournament. As you testified earlier, Miss Becker came to practice most unprepared you had ever seen.
Yeah, I don't think Coach Brackman really appreciated that, but she pulled it off as she always did.
And she was later demoted to the B team.
Yeah, Coach Brackman did demote her.
You thought Miss Becker deserved to be on the A team.
Oh, absolutely. That girl was A team material.
So you decided to quit the team in support of your BFF, as you stated earlier.
It wasn't a big deal for me. I didn't love mock trials, so yeah, I did it.
Yeah, Miss Perkins, you did not quit the team the day after Miss Becker was demoted.
It wasn't an immediate thought in my mind. I made the decision about a week before regionals.
Yes, Miss Perkins, you waited 3 weeks after Miss Becker was demoted, a week before the regional tournament, to quit the mock trial team.
It wasn't an immediate thought in my mind, but later on, that thought did pop into my mind, yes.
Leaving Coach Brackman no choice but to put Miss Becker back on the A team.
Well, if I wasn't on the team, the coach wouldn't have been able, or the team wouldn't have been able to compete. So Coach Brackman did have to, yes.
Miss Perkins, you quit the team a week before the regional tournament, so leaving Coach Brackman no choice but to put Miss Becker back on the A team.
As I just stated, if I stepped off the team, Coach Brackman would have to put Avery back on the team in order for the team to compete.
Thank you, Miss Perkins. Now let's talk about what happened at the practice after the regional tournament. After a heated practice, Miss Becker left and Sharpied Worst Attorney Award on the hood of Coach Brackman's Porsche.
Well, I wasn't at practice, so I don't know if it was like heated or anything, but Avery did write Worst Attorney Award on the car. But to my knowledge, she thought it was a...
Thank you, Miss Perkins. Now, when Coach Brackman saw this, he kicked her off the team for good.
That is when he did kick her off the team, yes.
In an effort to get back on the mock trial team, Miss Becker texted everyone on the team asking for help.
I don't know about everyone. I mean, like I did say everyone, but it's kind of like one of those metaphor things, like, you know, a lot of people, but I don't know exactly who she texted.
But you think she texted even Alex Cifuentes?
I couldn't tell you for sure.
Miss Perkins, is it your testimony here today that you don't think Miss Becker texted Alex Cifuentes?
I never said I don't think, but I told you I couldn't tell you for sure. There's always that possibility.
But you think Miss Becker texted Alex Cifuentes?
It could be a possibility.
Now, let's talk about March 5th. You and Miss Becker spent the day together after school.
Yeah, she came over to my house after school and we hung out.
And then the two of you went to the Fry Shack?
Mm-hmm.
And at that Fry Shack, you never saw Miss Cifuentes touch Miss Becker's phone?
I don't really recall, but I think that Alex played some games on Avery's phone.
Now, the next morning, Miss Becker picked you up for school.
Yeah, she did. We drive together to save some gas money.
But it wasn't until you pointed it out that Miss Becker realized her phone was missing.
I couldn't tell you if it's that exact moment because obviously, like, I'm not Avery, but I think that I do think that's when we kind of realized together that, like, it's missing.
Yes, and I heard Miss Becker say something on direct, and I wrote it down so I wouldn't forget it. She said she realized the phone was gone that morning, but you say you realized together in the car.
I want to verify with our timekeepers. I'm told we've run out of time. Is that correct for our timekeepers?
Yes, it is.
All right. Given that, we'll stop the examination at this point. Is there time remaining for redirect? I'm taking that as a yes. With that, Ms. Fix, was there any redirect?
Yes. Ms. Perkins, could you describe your relationship with Ms. Becker?
Yeah, we were like best friends all throughout high school. We did a lot of stuff together.
And when did you realize that Avery's phone was missing?
I personally realized it was missing when I had texted Avery the morning I went to pick her up, and she didn't respond to any of my texts.
Did Avery murder Mr. Brackman?
As I said, Avery and I are like two peas in a pod, and that pod was looking for Avery's phone the entire day that Mr. Brackman was murdered. So no, Avery did not kill Mr. Brackman.
Thank you, Your Honor. No further questions.
Thank you. In that case, Ms. Perkins, you're free to step down. Is there any additional witnesses or testimony by the defense?
No, Your Honor, the defense rests.
All right, at this time then, both parties have rested their presentation of the evidence, which means we'll move to the final stage of the trial, which are the closing arguments. We'll begin with the prosecution. Are the people ready to proceed with your closing argument?
Yes, Your Honor.
Mr. Powell, when you're ready, you may proceed.
Your Honor, counsel, members of the jury, towers, texts, and tantrums. On Friday, March 6, 2020, Mackenzie Brackman got an alert on his phone. Motion at your front door. Seconds later, he gets another motion at your side gate. He rushes to the kitchen to grab a defensive weapon, but before he could get to the back door, the intruder had entered his home. He fought with the intruder. He struggled for his life. He was stabbed in the back. And the bright light of Mackenzie Brackman extinguished as he bled out on his entryway floor. Little did he know, his attacker was Avery Becker. Members of the jury, my name is Chalmers Powell, and along with Madeline Proctor and Feliciana Sayers, we represent the people of the state of Colorado. In today's case, we carry the burden of proof. That means we have to prove beyond a reasonable doubt that the defendant committed second-degree burglary and first-degree murder. As the judge instructed you, a reasonable doubt isn't a vague, speculative, imaginary doubt, but a doubt that would cause you, a reasonable person, to hesitate to act in matters of importance to yourself. We have to prove to you that the defendant entered Mr. Brackman's home with the intent to commit criminal mischief. That is second-degree burglary. We also have to prove to you that that Mr. Brackman died while the defendant committed that crime. That is first-degree murder. We have met our burden. Let's talk about how. At the beginning of this trial, Ms. Proctor asked you to focus on three things: towers, texts, and tantrums. Towers. The towers prove that the defendant was near the victim's home. Her phone pinged not once, not twice, but 3 times right there. She wants you to believe that she just happened to lose her phone the day before the murder. But Taylor Perkins and the defendant can't even get their story straight. Taylor Perkins says it wasn't until the two got together that the defendant realized her phone was missing. And Ms. Becker testified that it wasn't until the morning of March 6th that she realized her phone was missing. Either way, the claim that the defendant didn't realize her phone was missing until the next day is not reasonable. Texts. The texts prove that the defendant had the intent to commit criminal mischief. I'm going to wait until he's at work, break in, and trash it. He admitted to it. He wants you to believe that Blair Rollins and Alex Cifuentes conspired against her to frame her and fake these texts. There's no reason for that to happen. That's the imaginary doubt. That's the speculative doubt. They just want you to imagine it. Tantrums. Avery Becker got mad when Coach Brackman criticized her work. She went out, threw a tantrum by vandalizing the car. After that, Coach Brackman kicked her off the team entirely. She was a mock trial junkie. She loved mock trial, but that had just been taken away from her. This created all the motive in the world to go and throw another tantrum. I'm going to get him back if it's the last thing I do. She did. Now Mackenzie Brackman is dead. In a moment, Miss Hayden is going to stand right here and try and sweep all of this evidence under the rug. Don't let her. Towers, texts, and tantrums lead to the truth. Avery Becker is guilty as charged. Thank you.
Thank you. Is the defense ready to give its closing argument?
Yes, Your Honor.
All right. In that case, when you're ready, you may proceed.
Thank you. Your Honor, opposing counsel, members of the jury. In this case, there was no phone, no files, and no felony. Might I remind you that the prosecution holds the entirety of burden of proof in this case. That means that they need to prove beyond a reasonable doubt that Avery Becker committed second-degree burglary and murder in the first degree. They need to prove every element of these crimes. Not only have they failed to prove every element, they've failed to prove a single one. The prosecution's case was saturated with incompetence, both in the evidence they did collect and in the mounting evidence they did not even consider. The phone, or should I say, phones. Both Detective Markowitz and Mr. Kuzak would like you to believe that they're sure of the whereabouts of my client on March 6th. They want you to think that the cell tower data that they collected tells us everything that we need to know. This simply isn't true. Cell towers aren't tracking devices. Phones don't always connect to the nearest one. Besides, regardless of the path that Ms. Becker's phone took on March 6th, it was not in her possession that day. On the other hand, there are two phones that Detective Markowitz did know the location of. Alex Cifuentes and Taylor Perkins' phones were not investigated in this case in the slightest. Detective Markowitz chose to hinge his entire case on screenshots sent to him by a teenager, and in his own words, he cannot prove whether or not they are real. Detective Markowitz also didn't bother to search Taylor Perkins' phone, which would have confirmed or denied Avery's alibi on the 6th. Next, no files. In yet another example of the police department's amateur work, photos of blood spatter were corrupted and lost in this case. Ladies and gentlemen of the jury, how can we say that this trial is over when its experts can't even keep track of its evidence? Finally, the felony. We know that, today, Avery Becker is being charged with 2 counts. First-degree murder and burglary in the second degree. Members of the jury, the prosecution has deemed this case, a typical case of a tantrum, some towers, and some texts. Might I remind you that Avery Becker did everything in her power to make up for her so-called tantrum of riding on Brackman's car? Might I remind you that these texts are not texts at all, but screenshots from a teenager? Might I remind you that these towers are simply an estimation of a phone's location and do not tell us who had Avery Becker's phone on the 6th? Let me tell you some things we know for sure. We know that the prosecution failed to look into any other suspects, including Blair Rollins, whose father, Mackenzie Brackman, sent to prison. Rollins was not at school on March 6th and seemed to have disappeared into thin air since then. This, of course, did not stop Detective Markowitz from reminding us that Rollins lives in the same cell tower range as Avery Becker. We heard the prosecution's only character witness say that she was jealous of Avery. She was excited for the roles that she would take on with Avery kicked off the team. Ladies and gentlemen of the jury, might I remind you that Alex Cifuentes was the last to see Avery Becker's phone on the 5th when she lost it? We know that there's not a shred of physical evidence in this case. The only things tying Avery Becker to this murder are assumptions and coincidences. Finally, we know that there's more than a reasonable doubt in this case. There's a sizable one. The evidence brought forth by the prosecution is fundamentally lacking in every way. There was no phone, no files, and there can be no felony. Since the prosecution has absolutely failed to meet their burden of proof, which is proving beyond a reasonable doubt that Avery Becker committed the 2 charges against her, you must find her not guilty. Thank you.
Judge, you're on
Apologies, I was talking while muted. I was saying, Ms. Hayden, thank you very much. And is there any final rebuttal from the people?
Yes, Your Honor. Members of the jury, Ms. Hayden got up here and tried to sell you the idea that there was no phone, there was no file, and there was no felony. But you know better, because you were paying attention during the entire trial. There was a phone. Avery Becker's phone pinged 3 times near the victim's home. There was a file, screenshots of the text messages proving intent to commit criminal mischief, and there was a felony. Felony first-degree murder. Find Avery Becker guilty of first-degree murder and second-degree burglary. Thank you.
Thank you. Based on that, the case will stand submitted at this point. First, a round of applause that I'll give to each of you. Certainly your coaches and family and everyone else will be giving those as well. It was a fabulous job. For our scoring panelists, what I'd like to do is I'll let you go ahead and check your score sheets, make sure they're full and complete. And then if you'll go ahead and click submit on those once you've got them in place, I'll get advised that we have all 7 sheets. And probably it'll help me if once you've got your score sheet submitted, feel free to go ahead and reactivate your camera. I'm not going to talk about performances because I want to let the score sheets go in place, and we're getting some of those in now. I've got to tell you, I helped write a lot of this problem. I just can't tell you how fun it is to watch all of you put it to life and bring it to life. I was very impressed. And once we get all of our truly distinguished scoring panelists ready to go and they've been able to look through their score sheets, I'm going to let them give some final critique in terms of that.
Your Honor?
Yes.
Sorry, this is a member of Team Cuba. I understand the trial's done. However, I do have a bloody nose. Do I have permission to go take care of that?
You absolutely do. Ms. May, feel free to go ahead and take care of that. I think
Thank you so much. Thank you.
Health issues are always a ground, certainly. All right, we're getting everyone in. As soon as we get everyone in, we'll go ahead and go over some critiques in just a moment. I like it's taking a little bit of time to check some of those score sheets. Frankly, I'm really glad I was not scoring. I was impressed across the board. That would have been a difficult thing for our panelists. I'm sure they'll tell you some of that in just a moment. All right, we're down to just needing 2 more score sheets.
John, I'm getting a server error when I try to submit. Are you getting my submission?
We have not gotten your submission yet. You can also just try and screenshot and you can email them to me as well. And this is Ashley Staub.
Ashley, can you help a technological idiot tell me how to do a screenshot on my computer?
Or could you just copy and paste? So just drag your mouse down and copy all of your answers and then paste them into an email and send it to me.
I will do my best.
I encountered the same problem, so I shall do the same thing.
Okay, perfect. Judge Madden, you're muted if you're trying to talk.
I am. That way it's a good thing. I was going to say it's interesting that our 2 Court of Appeals judges are the ones that we have somehow sabotaged their computers. I do know that the highlight and paste, if you click on it with the mouse and drag, it'll light them all up. You can stick them in an email and that'll work to Ashley as well. In fact, that's actually how we enter them into the score sheets now. So there's no hand transcription. I just highlight that section. We click the top and the bottom and stick it in a spreadsheet and it goes from there. I'm glad to know that there's always at least one technical error at the end here.
Judge Madden, the problem is that the numbers aren't copying. My scores aren't copying.
I'm having the same issue.
Let me try suggesting one thing. Well, that's going to be a little tricky. I'm going to turn back over to Ashley since she's our expert with that. If everyone will bear with us, we'll get past the technical part of that. We can probably go to plan C if necessary, but Ashley, I'll let you take over in terms of seeing if there's a way to get those to work.
For now, if you just want to send me the final point score for who won, and then afterwards, I don't know if you wrote them down or if you could just type the numbers into an email in order. I think that might be our best option, unless you can screenshot, but that'll depend on what type of computer you have.
And I was going to say that'll work since it's added them up at the bottom. If you just want to send an email where you type those 2 total points for both sides, and later we'll figure out how to get the exact breakdown of the numbers. That's a great idea.
If it's easy too, you might be able to do like control print on your screen and do a save to PDF instead and email it.
That's a great idea as well.
Or take a picture with your phone and text it.
Even more low tech, but that's a great approach.
Or just give up.
Yeah. We weren't going to count their scores anyway, so I don't know why we're worried about this. But no, we want all of these scores in. All right. And any luck just sending the final tallies to Ashley?
Yes, I got Judge Tao's, and it looks like Judge Bernard is doing that right now.
Excellent.
I'll send you the individual scores shortly after we're done.
Judge Tao, thank you.
Ashley, you should have that now.
As we do that, since we're getting them there, if for our competitors, if you could turn your cameras back on as well. All right. And our panelists didn't know this. We don't tell them going into this. These were 2 undefeated teams after the 4 rounds of state. So they both were going head to head as undefeated. I was very impressed watching that. I want to turn this over to our panelists who frankly are the experts in this area. And what I want to do is we'll just go across the top again in the order that I see you appearing on that. Justice Gabriel, any comments or suggestions that you have for any of our participants?
Sure, I'll try to be brief, but everyone who knows me knows I have trouble with that sometimes. First of all, congratulations to each and every one of you and to your coaches and to all the parents and all the people who supported you. It was phenomenal. We see a lot of lawyers. I mean, all of you, you're right in there with the quality of lawyers, lawyers who've been at it a lot longer than you've been at. So great job. Really, it's proud to watch all of you. So I hope most of you, if not all of you, are going to go into law because we'll look forward to having you at the bar. You'd be a credit to the bar. So I tried to kind of highlight quick things. And I'll just go through. First of all, I thought the openings and closing were excellent all around. I love the themes that you came up with. I loved on the defense side, the turning the prosecution's theme against them. That was very effective. I assume that was done on the fly, really well done. A couple of 2 constructive points I would make on those. One, be careful too much gesturing. A lot of hand gesturing. You don't want the hand gestures to be a distraction. So whichever team goes on, just be mindful of that. And on the defense side, I would say beware of taking on a burden on yourself you don't need to. In closing, you don't have to prove that the prosecution failed in every element. You just have to prove they failed in one. So just beware of taking on a burden that you don't need to take on yourself. But minor point, I just say that constructively. Going through just quickly, And if I fail to mention each and every one of you, please don't take that as insulting. I thought you were all phenomenal. So I don't mean that, but I'll just kind of going through. Mr. Powell, I thought you had such a wonderful presence on your directs and your cross, both and really excellent. On Detective Markowitz's testimony, I thought the evidentiary arguments on both sides were particularly good, very strong, really very impressive. In fact, Ms. Hayden, you made arguments throughout, evidentiary arguments, and I thought they were strong every time. Very, very impressive. I thought Mr. Phillips, you played a really excellent witness, and Kyle Cusack. I mean, it was you came across as not an advocate. That's an issue with real witnesses. The ones who are less credible, the ones who look like they're particularly an expert, too much of an advocate. And I thought you had a really nice temperament and responded and didn't get, overly engaged and overly, advocating. I thought that was really wonderful. Ms. Bruner, I thought you were just an outstanding witness. I love the kind of the cheerleader, character that you took on. I really enjoyed it. So well done. Ms. Fakes, I thought the cross, particularly of Alex Cifuentes, was superb. I thought you're just strong on direct and cross. Really nice manner, very good listener, and really you made really clear points. It was clear the points you were trying to make on both cross and direct. It came out to someone who hadn't heard any of this before, and I like that. And I had to say, I loved your cross. You ended your cross with, "You're elated to be here testifying today." I don't know if you planned that, but you picked up on the witness's kind of demeanor, and I thought that was excellent. I chuckled out loud when you did it. I'm glad I was on mute. Let's see, on the Professor Blake Van Owen's testimony, I thought the direct and redirect, Ms. Murphy and Mr. Powell, were just excellent, both clear points. Mr. Powell, I'd note too, you made really nice transitions in cross, which is not always easy. Let me turn to another subject. I thought was great. Let's see. On testimony of Avery Becker, I would say, again, both examinations were really good. I wouldn't wait to redirect to say, "You didn't kill this man, did you?" I think, unless I missed it, I don't know that I heard that on direct. I heard it on redirect. That's the first thing the jury wants to hear, that witness say, "Did you kill this man?" And I wouldn't wait. And for, again, if Ms. Becker, if your team goes on, be very careful about saying, "I heard the witness lie on the stand." On the stand, that is a big opening objection for the other side. One witness is not allowed to say another witness lied. So I'd just be careful about that. And I go on, but it was so impressive on both sides. It was very difficult to score because you're all really, really good. And unfortunately one team wins and one team doesn't, but you're all winners. And you should all be exceptionally proud of yourselves. I was proud to watch it. So thank you for the honor of being here on the scoring panel today. It was great. Congratulations to all of you. John, you're on mute again.
That's got to be the statement of 2020 and 2021. You're on mute. Thank you. Thank you very much for the comment. I'll just go in the order I have in terms of how they appear on the screen. So I'll go down the line. Judge Bernard, you're next on the screen. Any comments that you have?
Thank you, Judge Madden. We live in contentious times, and times in which people are more interested in shouting at each other, screaming at each other, ignoring each other. And we look around and it appears that we may have as a society started to lose the ability to disagree with each other in a civil way. And yet we have today. What a remarkable showing, and I mean a remarkable showing, of the ability of people to talk about an extraordinarily important thing, the murder of a man, involving extraordinarily important concepts. For example, the constitutional rights that the defendant has, and talk about that in a way that focuses on the differences in facts an argument without insulting each other, without tearing each other down, but in focusing on the issue. Bravo. I think that all the parents, all the teachers, all the brothers, all the sisters, all the fellow students, all the relatives, all the friends who have watched this today should be extraordinarily proud of what you've seen. I want to talk about just a few things. And as Justice Gabriel said, the fact that I don't mention everyone should not be viewed as any sort of negative thing. We just have limited time here, and I just want to talk about a few things that I saw that really stood out. First, the waltz of the objection. In real trials, objection and response is a form of dance. And you folks had the steps down very well. You knew the rules of evidence. You knew what they meant. You weren't just mouthing them. You understood how they applied. I was very impressed by that. Second, I too, like Justice Gabriel, was impressed with theme and counter theme, and particularly with the quick picking up by the defense on the prosecution's theme, and then trying to turn that. That was a sign of thinking on one's feet. Next, I enjoyed how experienced and prepared the witnesses were. For example, Mr. Phillips had just the right whiff of arrogance about his testimony. Statements like, you don't carbon date scuff marks, and it's an assumption I do know, are things that one could actually hear. And then Ms. Bruner, seemingly she plays, and this is not a comment about Ms. Bruner, this is her character, so please understand, I'm only talking about the character. The character seems to be an airhead, and yet suddenly an airhead with bite, who knows her not her role very well, the facts very well, and she could bite the hand of the attorney questioning her. What about the role of the prosecutor or the role of the defense attorney in direct examination? The idea there is, as I think Judge Madden would tell you, if you are doing direct examination, you want the witness to do the most of the talking. Indeed, I thought that Ms. Murphy did an extraordinary job of stepping into the background and letting the expert witness talk. She guided her deftly and gently. And last, about cross-examination, Mr. Powell, methodical, and then an excellent piece of impeachment when the comment about what was said during the trial of the father of the alternate suspect, what was said during that, he impeached using the audio of it itself, and he did it very effectively. Sometimes the best cross-examinations are not the most explosive or the most loud. They're the most methodical, consistent, making point by point. Thank you very much for letting me have the honor of judging this round. And thank you, Judge Madden.
Judge Bernard, thank you very much. Judge Tao, let me go to you. Any comments or suggestions that you have?
Thank you. And I reiterate the same honor and thanks to all of you for a wonderful experience. You clearly put a lot of time and a lot of effort into this. And I was, as I always am when I score these, but in particular, there wasn't a weak link. There wasn't anybody who didn't carry their water I'm not going to go person by person because I know we're somewhat under time constraints. And frankly, a lot of what I would have said has already been said. I have many of the same observations, but in more general sense, I agree. I really liked that the objections were handled well, and I want to stress one point. You handled well the objections both when making them and when choosing not to. And that's an important point. Everything that could be objected to doesn't have to be. If it's not hurting, don't take the time, and frankly, don't irritate the jury with interruptions. For example, all of you chose to simply not fight the credentials of the expert and instead attack what the expert did. And I think a lot of time is wasted in real trials fighting over the voir dire of the expertise when there really isn't any question that the person's qualified. It's really you just want to get straight to the meat and point out the problems with their opinion in this case. And that's the tack you all took with all of the experts, and I think that was an excellent choice. I agree. I love the theme. I love the counter theme. My father-in-law is a Lutheran minister, so I was taught early in my from his sermons that I used in my career, the alliterative triumvirate, as both of you chose, is always an effective tool, and you all operated it very well. In particular, I said I wasn't going to make any specific comments, but I very much liked the rebuttal closing to bring back their theme and say, so they tell you there aren't these three things. Well, here they are. Boom, boom, and boom. And I'm going to sit down now, and the jury's going to come back with my guilty verdict. That was confident, and it was effectively done. My one constructive comment would actually go to, I think, every one of the cross examinations had this issue arise. They're fudging their statement. They're backing off of their statement a little bit. And you did the right, all of you did the right first step. Is it your testimony today, X? Follow up. If it's different, show them the actual statement. Isn't this what you said before? So you've set the trap, but if you don't show them their statement and have them admit that in the past they said something a little bit different, then the trap never closes. And you leave a question for the jury because the jury hasn't seen that statement. So that'd be my one constructive suggestion. If you're going to impeach them on a prior statement, make them look at that prior statement and acknowledge that they made it. But that's just a very minor piece of constructive suggestion because you guys did phenomenally well.
Judge Tao, thank you very much. Justice Birkencotter, if you're ready.
Sorry, the mute button always gets me. Justice Gabriel can confirm that. Okay, so first off, I guess I want to sort of start where Justice Gabriel started, and that is to say to each and every one of you, if you have any interest in law, stick with it. Really, I mean that. Stick with it. You are an extraordinarily talented bunch of young folks, and the profession, I think, would really be well served if that's a dream that you have. I encourage you to follow it. I'm not going to go person by person simply because of time and because everybody sort of already touched on many of the things that I have said. You were all just phenomenal. Scoring was very hard. The couple things I wanted to touch on are as follows. Your preparation, I thought, really showed. There wasn't a hiccup, there wasn't a misstep, there wasn't, I mean, you guys just, you know this backwards and forwards, and I think you could really tell. The other thing I wanted to talk about was a courtroom is an amplifier in the most interesting way. It amplifies everything. So someone who is confident has to be careful that they are just confident and not arrogant. And you all did a beautiful job, I thought, with that. I also think that there's a kind of restraint that if you watch nighttime TV, or heaven forbid, you watch daytime TV, you don't see restraint, right? And even in some of the courtrooms that we have all presided over, you don't see restraint. But restraint really, really, really matters. And I thought you all just had a really deft, nice touch in terms of your tone, your demeanor. You were confident, but you weren't, like I said, you weren't arrogant. And I just want to commend all of you. I think that also crosses into sort of the terrain of professionalism and civility, right? Because it can be it's easy to be snarky, and there really wasn't any of that. The only constructive criticism I have is something that I have struggled with my entire career, and that is I'm a fast talker. Many of you are fast talkers. I had a court reporter that said, get a metronome, and I got a metronome, and I tick, 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 tick. And I will tell you, I still talk fast, quite frankly, but that helps. So that's my 2 cents.
Justice Birkencotter, thank you very much. Ms. Speraza. Oops.
Oh.
There we go.
Uh-oh. That's not good.
We lost camera, but kept audio, so we can hear you. There we go. Oops. Now we lost audio.
Hello. All right, I'm getting thumbs up, so that's always a good sign. I thought, echoing everybody who's gone before me on the panelist side, you all did an incredible job. It's also interesting being a practitioner and scoring this mock trial, and especially the final rounds as well, because I think that I echo a lot of the comments that have been made about, being able to pivot on your feet and being able to kind of pick up on the themes pretty early on and be able to shift more or less your opening, your closing, your narrative to fit the theme of the other side and be able to kind of turn that. I thought that was very effective and something that we do in practice as well. I thought that the arrogant versus confident that the justice just talked about was also awesome, because I would have to say in some of the other rounds that I judged, they teetered a little bit too much on that with, we welcome the burden of proof, which I was like, okay, it's a murder trial, so let's just keel it back a little bit. So I thought that was really well done. I thought the confidence was great. I thought the objections were really good too, and the responses. The one thing that did resonate with me was Judge Madden when he said something to the effect of, I usually don't allow a lot of back and forth with objections, because I will tell you, I had a trial last week, and the judge told me, well, this isn't a game of tennis. This isn't a game of ping pong, Ms. Barraza. And to which I replied, well, Your Honor, opposing counsel has just inserted a new objection that wasn't in her original objection. I would like the opportunity to respond to it. So I think that you're getting a lot of real life experience here when it comes to the mock trial, even though obviously this is a mock trial case and not an actual murder case. But I thought you all took it very seriously. You all were very well prepared. And I was very blown away and impressed, not just with the preparation with the attorneys and the counsels, but also the witnesses. It was just, I'm blown away. It was really, really well done. So congratulations.
Ms. Speraza, thank you very much. Ms. Gravitt.
Well, I definitely watched 2 teams that were in the championship round, and so deserving. I don't know where this is going to go and which team is going to win, but I know it's going to be really, really close. I'm happy to pass on my notes to Judge Madden if the coaches would like, but I always have given the advice of I let the coaches do their coaching. It was excellent watching you guys. I just want to commend both teams and parents and coaches for all the time. I mean, you're doing the championship round on Zoom. This is not easy. Some days it's not fun. And I just think you should be all so proud for doing it. A lot of people would have given up or dropped out, especially after not being able to perform last year at state. So I just cannot commend you enough. I know how many hours your coaches have put into this. So I can't see your coaches, but I commend them as well. I also would just want to all across the board say I really appreciated you guys following through with your themes and really pulling them in into your closings. That's huge for me. There were times where I really did feel like I was in a courtroom, and I really was hoping to feel that way, and I did. The professionalism you guys showed is amazing. I think we have all seen how the lack of professionalism can really shine through in some of these Zoom trials in real life. And so I just thought that was phenomenal. And really, my other note is Miss Proctor and Miss Hayden, you are not a cat. And I hope that you guys really consider law school. There's a million things you can do with your law degrees. And you are just overall so impressive, each and every one of you. Thank you for having me.
Ms. Gravitt, thank you very much. For Judge Jackson, I don't know if it's good to go and get the last word, or you get the word when everybody's like, oh, are we almost done yet? But I'm going to give you the last word. Any comments or suggestions that you have?
Well, first of all, it was a pleasure to be able to observe this. I think of this group, I am the oldest and the most senior in terms of years of trial practice and years on the bench. So I've been doing this for now 50 years. And I have seen trials and have been involved in trials from municipal court all the way to federal court. And I have seen lawyering that individuals have 1 month experience or 50 years experience. And I can say that for both of these two teams, I rated 10 each for professionalism. And that was so impressive to me. I could also rate, if I'd had the opportunity, 10 each for preparation, because I could see the preparation that was involved by not only the lawyers, but the witnesses. Each one of you was very, very prepared. And when there is professionalism, what goes along with that is integrity. And I can tell that each of you has the type of integrity that I look for, whether it be as a litigant in my courtroom or on the opposing side as a trial lawyer during the 37 years that I was a trial lawyer. So bottom line, your coaches, your parents, your friends that have all been involved in putting you where you are, I look forward to each of you, if it's your choice, to continue, whether it's at the University of Colorado or Harvard, that you have the type of abilities that you can be successful at any one of those law schools. And I thoroughly enjoyed the work that you did. So best of luck.
Judge Jackson, thank you very much. And I love the position that they can go to the best school like CU Law School, or they can go to almost as good at Harvard. I say that as a CU alum and some of our other people. As indicated, I'm not going to give any additional comments. I don't think I could top any of those. I think they were spot on. And I think all of you are ready to find out who should be moving ahead. Briefly, for our scoring panelists, since it's the question we usually get, you should get to know our two teams that are competing. Team Morocco, as the prosecution, is from Regis Jesuit High School, and Team Cuba, who is our defense, is from St. Mary's Academy. It was neck and neck through this process. They were the only two teams to go undefeated. They knocked out a lot of great competitors. And of course, for all of our competitors, this ended up being a 4-3 split. It came down to a single ballot. You were that close all the way throughout this. Without any further ado, the team that had the 4 ballots and will be proceeding to represent Colorado in the National High School Mock Trial Tournament will be Team Cuba from St. Mary's Academy. Congratulations. We will get in touch with your coaches as well. We'll leave the room open for a moment in case any of you want to check with our panelists, but you're not required to stay at this point. We'll get in touch with the teams to talk about how we'll be competing in the nationals. For our scoring panelists, thank you again. For our staff who've helped us with that, Ashley and Amy and everyone on our staff who's helped us. Thank you so much for that. Again, also thank you for the litigation section for helping fund for this and for our panelists. Thank you all very much. Have a wonderful evening. Drive safe before the snow gets bad if you have to travel, and good luck. Have a good evening.
Thank you so much.
Thank you.
Well done.
Thank you, you as well.
Yeah, Team Q, you can stay for just a moment for a team
Thank you,
picture.
Amy and Ashley.
Oh, exactly. And I forgot about the team picture. We were going to possibly take that. Oh, we probably took some with that. So we'll go ahead and keep our panelists, and I can drop out, Ashley, if you need me to, or if you want to take a picture with our panelists and our teams.
Yeah, so then if, Amy, do you want to just turn your camera off and I'll turn mine off and then we'll get a picture with them with the panelists? Okay, smile. Okay, awesome. Thank you, guys.
Impressive. Thank you all so much. Have a wonderful evening. Thank you all very much. I'm going to log out as well, but certainly feel free to ask any questions with each other. And thank you again.
Thank you
Congrats, everyone. Thank you, John.
So much. Thank you.